Good morning. Welcome to our webinar, Domestic Violence Awareness, a survey of critical issues for family law practitioners. We have a great program set up for you today. My name is Janet Heppard. I was the presiding judge at the 387th Family Court in Fort Bend County, previously taught in and directed the clinical program at the Law Center, and I'm now retired and teaching a domestic violence writing class at the Law Center. Maisha, you would introduce
Good morning,
yourself.
everyone. Thank you so much for taking the time to join us this very nice October 31st. Happy Halloween. My name is Maisha Coulter. I am the CEO of Aid to Victims of Domestic Abuse. And we have been doing this particular October seminar now, I think, well, if my memory serves me correctly, since 2014, we started doing them in person at U of H, and we have since gone to these virtual presentations annually, usually in October. Every once in a while, we have to push it to November. But we think that we are offering you an opportunity to get free CLE on a topic that is, I think, near and dear to most family law practitioners' hearts. And so we want to continue to provide services in a way that is trauma-informed. And most of what you will hear today is steeped in that. In addition to that, we want to provide you with the opportunity to potentially hear from subject matter experts who perhaps may dig a little bit deeper into representation of survivors of domestic abuse than ordinarily provided by general practitioners in family law.
And just as a reminder, we do have a Q&A click on the bottom of the webinar so that if you have questions, if you would post your questions there, Maisha and I as moderators, we will watch over those, answer some questions as we can, but some of the questions will get answered by the speakers when they finish their presentation. So we also would ask that we're not going to answer questions that are specific to a case, just more general kind of questions, but we'll be monitoring that. Anything else, Maisha, that you could think of for the intro?
No.
Okay, well, at this time then, I get to go first. I'm going to begin this morning with a case law update related to our family violence topic, along with a review of the protective order related statutory changes that were made during this last legislative session. So I'm going to go ahead and share my screen. Very good. So I have 4 cases that seem to be relevant that came out this year. Most of them came out in May, interestingly enough. The first case was a Texas Supreme Court case, Sterry v. Etheridge. Mom and dad divorced in 2018 with an agreed custody order for their 3 children. In March of 2020, mom was arrested and charged with felony injury to a child. The charges were dismissed in February of 2025. Dad applied for a civil protective order for the children a week after mom's arrest, alleging family violence and seeking a protective order lasting longer than 2 years. At the hearing, dad testified about instances of mom injuring the children, supported by medical records. Of course, the court also interviewed the children. The trial court found that mom committed felony family violence and issued a lifetime protective order prohibiting all contact between mom and her children. So those are the basic facts. So what happened next? The trial court's decision was appealed with a claim by mom that the lifetime no contact protective order was equivalent to a termination of parental rights. The First Court of Appeals in Houston affirmed that order. The Supreme Court of Texas held that constitutional due process requires clear and convincing evidence to support a protective order prohibiting contact between a parent and their children for longer than 2 years, emphasizing that such orders profoundly interfere with a parent's fundamental right to care, custody, and control of their children. The court reversed the judgment of the Court of Appeals and remanded the case to the trial court for further proceedings, requiring the trial court to apply the clear and convincing evidence standard and to consider the best interests of the children. So this is an interesting case. We don't know if ultimately attorneys will be able to expand it into the custody orders that restrict parental rights, but we'll see how that goes. And now we have a clear standard if a protective order is being sought for more than 2 years. The next two cases I thought were important because they both relate to attorney fees and protective order cases. In the first, Vo v. Wynn, girlfriend sought a protective order against her boyfriend. At the final hearing, when the boyfriend's attorney presented testimony regarding fees, he stated, "I've been licensed since 1999. I've worked more hours than what I charged on this case, but I told my client that my total fee would be $6,000. I normally charge at the rate of $350 per hour on these matters." And that was essentially his testimony. The trial court orally denied the girlfriend's protective order application and granted the boyfriend an award of $6,000 of attorney fees. The day after the hearing, the boyfriend's attorney filed an affidavit in support of the request for fees and attached his billing statement. Though the girlfriend objected, the trial court signed a written order conforming with the oral ruling. The following day, the court held a hearing on girlfriend's objections and overruled them. Girlfriend appealed. So what happened next? The girlfriend appealed, arguing that the boyfriend was not entitled to fees because the evidence was insufficient to support the attorney's fee award, and there was no affirmative pleading requesting attorney fees. The Court of Appeals noted that the family court authorizes an award of reasonable attorney fees related to an application for a protective order in Texas Family Code Section 81.005. The Court of Appeals also noted that the boyfriend's attorney's testimony did not identify the particulars required to request and get an award of attorney fees. Although the attorney subsequently filed an affidavit with the information, the affidavit was filed the day after the case was assessed and the fees were assessed against the girlfriend. The Court of Appeals found that the trial court erred in awarding fees because they were not properly proved up. The judgment was modified to vacate that award and affirmed as modified. This is a reminder again that you need to prove up your attorney fees. The other thing in this case to note, and the court didn't really talk about that, was that Texas Family Code 81.005 regarding attorney fees in a protective order are attorney fees awarded to or ordering the respondent to pay the attorney fees when an application for protective order is granted. So that came out in April. And then in May, we had this case, Landa v. Rogers. And in this case, Landa and Rogers are parents of a child. On February 1st, 2024, Landa filed a protective order and claimed indigency against Rogers, who filed an answer denying the allegations. Rogers also requested attorney fees, claiming the application was frivolous and designed to harass him. The protective order was denied, and Landa was ordered to pay attorney fees to Rogers pursuant to Texas Family Code 92.001, which talks about immunity regarding attorney fee, except you lose immunity if you report family violence in bad faith, and they're based on a bad faith family violence report to the police. Landa didn't object to the attorney fee awards at the time of trial. So this case is interesting because, well, what happened next? Landa filed an appeal objecting to the award of attorney fees. And I noted here, although timely requested, no findings of fact and conclusions of law were filed. The Court of Appeals, which was the 14th Court of Appeals in Houston, reversed the part of the trial court's order awarding attorney fees to Rogers, rendered judgment denying his request for attorney fees, and affirmed the remainder of the trial court's orders. And they were very clear, stating that attorney fees in a protective order proceeding may only be awarded against the perpetrator under Texas Family Code 81.005 and may only be awarded to another person under Texas Family Code 92.001 if a false allegation of family violence has been made in bad faith to law enforcement. So this helps clear up, and who knows how this case affects the case I just talked about in terms of attorney fees. The last case that I want to mention is a matter of the marriage of Bryant, which also came out in May of this year. This one is an interesting case. This is not somewhat related to protective order, but the overall case isn't related to protective orders, but more related to proving up family violence. So in this case, the husband and wife married in 2018 and had 2 children together. During the marriage, wife alleged instances of family violence against her. Husband denied those allegations and claimed that the wife only made those allegations when the parties discussed the possibility of divorce. Husband filed for divorce and conservatorship, and shortly thereafter was arrested for violating his bond conditions from a previous assault allegation arrest, allegedly stalking wife, driving by the house, and for possessing 2 handguns when he was arrested. So this was related to one of those assaults. Wife filed a counter petition, sought both a protective order and to be appointed as a sole managing conservator. Ultimately, during a hearing, the protective order was denied. That hearing was in September of 2023. And then at the final divorce trial in January of 24, there was a lot of testimony about mom's claims of family violence. The court, though, asked extensive questions of wife and her witnesses about wife's family violence allegation. The jury's no bill of the criminal charges that had previously been filed against the husband and her alleged recanting of the family violence allegations, expressing disbelief about the allegations. At the end of the trial, the court appointed husband as sole managing conservator of the children in the divorce. So this becomes interesting because the Court of Appeals didn't buy that. Wife appealed the divorce conservatorship, not the protective order, claiming that husband had no pleadings requesting to be named sole managing conservator and objecting to husband's appointment as a sole managing conservator being in the children's best interest. The court noted the following in their ruling, that the court, and this is just a reminder to us, the court has the discretion to appoint either husband or wife as sole managing conservator, whether one or both parties had pleadings on file to be appointed as a sole managing conservator. In this case, they found that the appointment of husband as sole managing conservator was against the great weight and preponderance of the evidence. And they also noted that while a judge generally has the ability to question witnesses at trial, the trial judge's conduct in this case was so egregious as to deem the judge biased. This claim of bias could be raised for the first time on appeal. So the Court of Appeal also noted, because this was some of the evidence, and I've put this in here because it's good for us as attorneys to remember, that a grand jury's no bill on allegations of family violence does not mean the incident did not occur. It also doesn't mean that that incident can't qualify as an act of family violence under the family code. And also that recantation of prior accusations of family violence is not uncommon. And this reminds us that that is true. Those of you who regularly practice in this area know this is true, but it helps remind us. The Court of Appeals remanded for a new trial on the issue of JMC or SMC appointment. So they affirmed in part, reversed in part, and remanded in part. Interesting. So this is a really good case to read if you have these kind of issues, because the court also admonished the judge regarding their bias and made note that, well, we can remand it back to that same court because that judge is now retired, so a new judge would be hearing the case. So next I'm going to turn to the statutory changes made in the last legislative session. Most of the changes are pretty minor, and I'm not going to read the slides. the slides will be available. I just want you to know what, which changes have been made so that you think about if it comes up in your case, you know, oh, well, I need to make sure that I have a current copy of a particular statute. So the first one has to do with applying for a protective order and confidentiality of information. And you can see here, I tried to highlight on the slides in yellow which things have been changed. So it's easy to go back and you to be able to tell what the changes are. So in confidentiality, the court changed a may to a shall, or the legislature changed a may to a shall regarding applicants' mailing address and county of residence. So just know, and that's all of these now, these changes are now in effect, but they're in effect for cases filed on or after September 1st of this year. In chapter 83, under temporary ex parte orders, that 83.005 was repealed. This information, these orders, this what you need to know is also in another in another statute. And so that was why it was not needed. It seemed like what the legislature did mostly in these statutes is to just clean them up a bit. So under the required findings and orders, that this was, wow, this is a small change. So all they did, and my next slide is the 85.0025. They just modified that slide a little bit related to protective orders for a period of more than 2 years. So here's 85.025, which was related to the duration of a protective order. So they added these provisions, and these provisions are all related to if a divorce, a custody case, or there's a criminal case pending, and what that means to the duration of the protective order. So in all these cases, for example, if a divorce is pending, the order is effective until the second anniversary of the date on which the final decree of dissolution of marriage is approved and signed by the judge. So you just need to know that if you have these come up in your cases, if there's a custody order that's been filed at the same time, the order is effective until the second anniversary of the date on which the final order in the suit is rendered by the court. And if there's a criminal case, the order is effective until the second anniversary of the date of the final disposition of the criminal case. So it sort of extends the duration of these protective orders. So you need to know that that's there. Another change, this really more of a wording change, is the confidentiality of certain information. So I had some things were amended, and this slide shows what was amended. They added, or they just changed the wording, I think, to make it clear with the county of residence and the address and telephone number. So again, all this is effective as of, this is for protective orders pending or filed on or after the effective date of this act, which is September 1st. So within that same statute, the court also added an A1 which requires an additional reading of certain rights. In a hearing on an application for protective order, the court shall inform each person described by subsection A, which I don't have here, who is present at the hearing of the person's right on request to have information described by that subsection, which is the address, county of residence, excluded from the protective order, and specifically ask the person if the person wishes the court to exclude that information from the protective order. So as attorneys, you need to remember to, if you represent the applicant in the protective order, to make sure that this is done and on the record. Another change in the warnings for protective order. During the time in which this order is valid and subject to transfer, this is related to, well, protective orders that you might transfer. The order prevails over any other order rendered in a suit for dissolution of a marriage or a custody suit to the extent of any conflict between the orders. So that's just the additional warning. My next slide, there was some changes to the transfer requirements for a protective order, and that's come up more in Harris County because Harris County has a court that separately hears protective orders. But the court added when they talk, or the legislature added when they talk about transferring protective orders, the court has to make a finding that the transfer will not negatively impact the safety of any person protected by the order. So that was an addition. And then Part B changed a may to a shall. And again, the court has to make this finding that it's not going to negatively impact anybody. So divorce, custody case, or divorce with custody for this statute. We had a couple of additions also to this statute. And how it needs to be filed with the court. A motion to transfer protective order under this section has to be filed with a signed certificate of service on all persons, which typically we do when we file a motion. And a party desiring the motion must file a response not later than the first Monday after the 20th day after the motion is served on the party, which is similar to a motion to transfer in a non-protective order case. And then the response has to include a controverting affidavit. And then C2 is regarding the notice of a hearing and when the motion to transfer, the timing on the hearing request has to be served on the other party, the notice of hearing at least 10 days before the date of the hearing. So this is probably the statute that was changed the most. There weren't a lot of changes. In addition, the court added a C3 and a C4 regarding what the court needs to do, what the attorneys need to make sure happens in terms of sort of due process on these motions to transfer these protective orders. So you just need to know, again, that's there. In 87.004A1, which has to do with the change of address. On a request by a person protected by an order, the court shall keep confidential the changed address or telephone number. So this is also related. It kind of goes back to one of the earlier statutes. I think they're trying to, that we talked about, they're trying to make sure the language matches in these different statutes about confidentiality really of the address and county of residence. So attorneys, you need to make sure this happens. I understand in some counties, this has been harder to make sure that it gets done. Now we're going to turn to, there were a couple minor changes in the Code of Criminal Procedure Protective Order statutes. And our next speaker is going to be talking more about actually what the protective orders are within the family code and within the Code of Criminal Procedure. The main thing you need to know here on the magistrate's order of emergency protection is the change in how long those MOAPs, as we think of them, are effective. So on they're either 91 days, between 61 and 91 days instead of 31 and 61, or 91 days to 121 days instead of 61 to 90 days. So that's the only change in this statute. Again, I tried to highlight this so that you would see what that change is. The next one is in addition, a person who is victim of an offense of under section 30.02, which is the burglary statute, I had to look that up, is punishable under subsection C2 or D of that section, related to state jail felonies, has been added to who can file a protective order under the 7B protective orders section. So a person who is a victim of an offense related to burglary. So that's something to be thinking about in regards to your protective order cases, whether this potentially is another claim you can make for a protective order under these Code of Criminal Procedure statutes. The temporary ex parte order, they just cleaned up. They deleted the sexual assault or abuse, indecent assault, stalking, trafficking, and just referred you back to Article 7B001, A1 or 2, which is what I was talking about in the previous slide. Again, in this one, required findings. There were amendments, and you could see here what the amendments were. We deleted the specific reference to sexual assault or abuse, indecent assault, stalking, and trafficking, and just referred everybody back to any of the offenses listed in 7B.001. So it's just more of a cleanup, trying to make it, well, I assume just as a cleanup. The duration of the protective orders also just refers you back to the 7B.001, which is your application, and just kind of had a rewording. And since I added a 2 to that 7B.001, that's what now this talks about. Just know that that change is there. In the harassment statute, we had one addition. So one of the things that happens in these Code of Criminal Procedure statutes is they often refer to the stalking and harassment penal code statutes, and there was an additional provision added to the harassment statutes. And they added a 10. A person commits an offense if with intent to harass, annoy, alarm, abuse, torment, or embarrass another person. The person makes obscene, intimidating, or threatening telephone calls or other electronic communications from a temporary or disposable telephone number provided by an internet application or other technical means. So know that that's one more provision that can help you prove up a harassment type of protective order application. There's a little part of that statute that was more recently changed to becomes effective December 1st of this year instead of September 1st. And that's related to people harassing the court staff or a judge. So if there aren't any questions, I'm going to end my slideshow. And stop my share. And how am I doing? Oh, okay. Our next speaker, I'm going to, she's ready. Our next speaker is Melissa Pickett. And Melissa is at one time worked for AVDA and is now an associate at Jenkins and Kamen LLP. And she's going to talk about protective orders in both the Family Code and the Code of Criminal Procedure. Go ahead, Melissa, and I will get off.
Thank you. I appreciate you allowing me to speak today. I could talk for hours about protective orders, but luckily for you all, they only gave me 30 minutes. So what I'm going to do is give you a general protective order overview. We're going to discuss filing protective orders under the Family Code, Title IV, and also under the Code of Criminal Procedure. So as Judge Hepburn discussed a few minutes ago, she mentioned MOEPs, but I will not be speaking about MOEPs today. This will just be Title IV protective orders and Code of Criminal Procedure protective orders. So first, let's talk about Family Code Title IV protective orders. The Family Code Title IV has changed over the last couple of years significantly in this area. Many of you may know that we used to have a requirement to show that family violence had occurred and was likely to occur again in the future. The likely to occur again in the future element was removed by the Texas legislature. And so now TFC 81001 says that the court shall render a protective order if the court finds that family violence has occurred. So we no longer have that other prong. And what's notable is that this is opposed to a 7B Code of Criminal Procedure PO, because protective order under the Family Code is only available to members of a household or family of the alleged offender, or a person in a dating relationship. So there's some connection to the alleged offender, whereas the Code of Criminal Procedure protective orders do not require that same connection in order for you to have one granted.
Melissa,
Yes.
just a moment. Your slides are flashing, and I just
Oh,
make sure you knew that. And
okay.
you're not seeing
Oh,
the
okay.
hands. It's still on your first slide.
Okay. Okay. Can you see my next slide?
I can see the column of slides and your
Okay.
first slide.
It
Okay,
looks
let
like
me
you
ch-
haven't started the slideshow.
Okay, let
So
me
go back
start
to
that
what you
again.
did and then just restart it, because for whatever
Okay,
reason, I don't
got
think
it.
it really started.
Okay, let's see. I'm gonna go to start that again. Okay, can you see it now?
No, it still hasn't
Okay.
it still hasn't actually started.
Okay.
There we go. Now we got it.
All right, great. Okay. So can you see the second slide?
Yes.
Okay, great. All right. So this
Now
is
there
the
you
first. Great, thank you. So this is the slide. The first one is just the basics of a Family Code Title IV PO. And as I stated, under 81001, the court shall render a protective order if the court finds that family violence has occurred. And then the second prong is no longer applicable, as it was removed by the Texas legislature. Here are some of the applicable definitions for a Title IV protective order. I won't go word by word through these, but what I just want you to know is that here are the ways, or what constitutes family violence under Texas Family Code Section 71004. And so family violence includes an act, but it also includes a threat. And so one of the things that I realized over the years of handling family violence protective order cases is that a lot of times these cases don't actually involve what an act of family violence under 71004. But if you look at the statute, an act and a threat are placed on a level playing field in terms of both meeting the definition of 71004 family violence. So you may have a client where there has never been an act, but there's been a threat, and they still may qualify for a protective order under Title IV. 71004 also includes abuse, as it's defined under 261001, and that's going to be a list of types of child abuse. And so that would be included and roped into the 71004 definition of family violence. And then dating violence, as it's defined by Family Code Section 71021, is also going to be included in 71004. That's going to include both an act and a threat, just as subsection 1 does. What are the burdens of proof when you file a protective order under Title IV? Well, up until the Starry v. Etheridge case, the burden of proof was a preponderance of the evidence that family violence has occurred. And the court in Roper v. Jolliffe once considered, well, why wasn't it clear and convincing evidence originally for protective orders? And the reason why is because the interests at stake don't rise to the level of things like an involuntary termination of parental rights. And so these protective orders originally did not require a burden of proof above preponderance of the evidence. However, Starry v. Etheridge has changed that for us. And so as Judge Hepburn previously stated, the Texas Supreme Court said, well, now whenever you've got a protective order that's going to be longer than 2 years and prohibits contact between a parent and a child, now for those protective orders, you're going to have this higher burden of proof of clear and convincing evidence. And then you also have a second requirement to show why no contact is in the child's best interest. So those are the two now burdens of proof for a Title IV PO. What is preponderance of the evidence? Well, Black's Law Dictionary gives us this long definition, but what it really means is more likely true than not true. And so that's going to be for a protective order that's under 2 years, or one that's longer than 2 years, but does not involve a child and a parent with no contact. And then clear and convincing evidence, that's defined as in Texas Family Code Section 101, 007, it's really a firm belief or a conviction. So clear and convincing evidence is higher than a preponderance of the evidence. And interestingly enough, this definition of clear and convincing evidence is found in Title V of the Family Code, which is the parent-child relationship. It's not in Title IV, but the Starry v. Etheridge Supreme Court case, in that case, the Supreme Court looked to this definition in Title V for that standard, that burden of proof. And then also, you have this burden of proof when you're trying to include a child in a PO. And the courts are somewhat split on that. In the Martin v. Martin case out of El Paso, the court said essentially that you do have to prove that family violence was committed against a child if you want to include a child as a protected person on your final protective order. Whereas the 14th District in Houston, in Dulgener v. Dulgener, found and held that because children are at risk of family violence, even if they've never suffered harm, you do not have to create that nexus between the act of or threat of family violence or anything that falls under 71004 having been committed against a child in order to include that child as a protected person on the PO. So what are the durations of POs under Title IV? Judge Hepburn previously referred to some of this. Under the temporary ex parte protective order, there are different amounts of time that it can be in effect, and the court is mandated to schedule a hearing date within those dates. However, it can be extended for additional 20-day periods, and unlike a temporary restraining order in a divorce case or a SAPSR, a temporary ex parte protective order conceivably can be extended for multiple 20-day periods. And then, of course, under Title IV, the final protective order, it can be up to 2 years unless an exception applies. But what I like to tell people is that the 2 years is not a default. Just because it says that it can be in effect for 2 years doesn't mean that it can't be in effect for less than that. So if you're on the defense side and you're defending the protective order, consider either having an agreement that it will be fewer than 10 years or asking the court when you're defending the protective order to make it in effect for fewer than 2 years. And then, of course, it can go beyond 2 years if you show that there was an act that constituted a felony offense, and that doesn't mean that someone has to have been convicted, or whether there's serious bodily injury, or if the respondent was the subject of 2 previous POs and after the court finds family violence. However, these beyond 2 years sections in the Family Code are obviously subject to the new ruling in Starry v. Etheridge if you are trying to have 2 years or more of no contact between a child and a parent. What is some of the requested relief that you can ask against a respondent? I'm not going to go into each and every one of them. There's a long list. If you've ever filed a protective order before, you know that that's a really long list. But what I like to point out is that 85022 only applies to respondents to someone who has been found to have committed family violence. Why is that important? It's important because if you represent the applicant and the applicant has not been found to have committed family violence, which they wouldn't be if they're the applicant, then the court should not be ordering the applicant to do anything under that section. And also, you want to make sure that you don't agree and have a proposed agreed order where your client, if they are the applicant, is doing anything that would be found under that section because they were not found to have committed family violence. If the judge does order your client to do any of those things, make sure that you preserve the record by objecting. Now we're going to talk about Code of Criminal Procedure Article 7B protective orders. And what's really primarily different from these protective orders is that they can be granted regardless of the relationship between the applicant and the respondent. And so these, it's a much broader ability to file a protective order under this article. In order to get a 7B001 protective order, the applicant must show reasonable grounds that the applicant was a victim of one of the following. And as Judge Hepburn stated earlier, that now includes burglary. But what's interesting about this is that you don't have to show that there's been a criminal conviction. You just show that the applicant was a victim. And so it doesn't mean that you have to show that it occurred with proof beyond a reasonable doubt. You just show reasonable grounds that your client, it's actually about the status of the applicant and not about the guilt of the respondent. And then if you want to get an Article 7B051 protective order that's specifically about stalking, the filing procedure for both types of Code of Criminal Procedure POs will follow Title IV protective orders. So even though the Code of Criminal Procedure will say, here's what your burden of proof is, here's what you do for a temporary ex parte PO, you still go to Title IV when you're looking at the procedure and the process and the requested relief. And here with a stalking PO, again, this can be requested regardless of the relationship. So they don't have to be a family member or a member of a household. You don't even have to have been in a dating relationship in order to file one of these. And under this, under a stalking PO, the burden of proof is even lower. It's probable cause. And you have to show probable cause that the applicant was the victim of stalking or harassment. And here you have to show that probable cause exists to believe that the offense, stalking or harassment, was committed, and that the nature of the scheme or course of conduct engaged shows that the defendant is likely to do that in the future. So the Code of Criminal Procedure stalking PO still does have that future component. What are the burdens of proof here? So the reasonable grounds and probable cause. Both of these are lower than preponderance of the evidence. Both of these are lower than clear and convincing evidence. So when you are analyzing a case to determine what type of protective order to file, or whether you want to do one both under the Family Code and the Code of Criminal Procedure, that these POs are actually carry a lower burden of proof and therefore may be easier to prove and get a PO under them. So reasonable grounds has never been that I have seen, and I've looked at hundreds of cases, has never been specifically defined. But you can look to some of the criminal cases that involve reasonable grounds where law enforcement officers are obtaining evidence, obtaining DNA. And so we get from those cases that reasonable grounds is really more than just a hunch or a suspicion, and it's supported by, some reliable information. Probable cause, again, we look to some of the criminal cases in finding out what that means. And that probable cause exists where the facts and circumstances within the officer's knowledge show that there's some reasonably trustworthy information. Now, unlike reasonable grounds, we do have an idea that probable cause, this definition applies to protective orders because in the court case Garza v. Renteria, the court used this definition in the protective order context. So they looked at criminal cases to get that definition of probable cause. What is the duration under a Code of Criminal Procedure protective order? Well, if you ask for a temporary ex parte PO, you're just going to follow Title 4, Section 83002. And then with a final order, the duration is different than a Title 4 PO. It can be for a period stated in the order, and it can be for the lifetime of the offender and victim or any shorter period, but it shall be for the lifetime if the offender is convicted and placed on deferred adjudication for an offense that's listed in 7B001 and is required to register as a sex offender. What's important to know is that for a final order under Code of Criminal Procedure protective order, if the order doesn't specify a time, it expires 2 years after the date of the issuance. So if you get one of these POs, you really want to make sure that you both request a specific time and that you make sure that that's in the order. How do we file a protective order in Texas? So now I'm going to talk about the procedure of filing one. And first and foremost, now we need to use the forms that were created by the Office of Court Administration. So Senate Bill 48 directed the OCA to create these protective order forms, and that's now codified in Section 82004. Any person filing a PO shall use the mandatory forms that were issued by the OCA. They are available in Word format to fill out online. And that is the website that they're available at. This slideshow will be available to any participants, so you can have that website. I think many courts put these now on the link on their website, or they put the forms themselves on their website. But what's important to know is that the failure to use the forms does not affect the validity of the enforcement of a temporary ex parte PO or a final protective order, but you are mandated to use these forms now. And so there's going to be a little bit of a change in 82004 after December 4th, 2025. You've got to put the county of residence of each applicant unless the applicant requests that confidentiality that's under the new section. And then you also need to add any additional information known by the applicant to assist in finding the respondent. And so that'll go into effect after December 4th. Until December 4th, you just use the form as it's written and you provide all of this information when filing the application. Here are the mandated forms and the discretionary forms. So the three mandated forms that you must use are the application for the temporary and final protective orders, the temporary ex parte order, and the final protective order. So you really need to use these three forms. But the discretionary forms that you don't necessarily need to use, and you can use a traditional pleading, are for any additional orders regarding possession and access to a child, for child support or use of property, a motion to vacate, a motion to modify, and even the TCIC form. Although I would, as a practice tip, recommend that you continue to use that because that is the form that law enforcement uses in order to have it in their system as a valid existing protective order. Here are some tips for completing the new forms. Read the forms very carefully. I know that sounds very intuitive, but there is a pro and a con to having these forms. One, it makes it easier to file them. However, it also makes it easy to miss things. And TRCP 301, which is the rule about you can't get what you don't plead for, applies to protective orders. So if you go through that form and you're checking off or you're not checking off something that you need to show in order to get relief from the court, then that may affect your ability to move forward at trial. So my recommendation is that every single time you have a new protective order application, you want to look at it anew, match it to the individual facts of your case, and then you need to treat it like any other pleading that you are drafting from scratch. You want to read over it, get someone else to read over it. Make sure that you check everything that you need to. Also, in the application, there are many options that state mark all that apply. So there may be 2 responses. So you want to make sure that you're checking everything that applies because you may get you may get relief on one of those, but not get relief on another. So you want to make sure to include everything that you can. You also should supplement. There's nothing in the OCA form or in the new statute that says you cannot supplement and add to the form. For example, the form only lists 4 children. It only allows for 2 names of other protected adults. And the affidavit part and unsworn declaration parts of that form are very limiting. So if you believe that there's more information that you need to provide to the court, you can supplement that and attach it to the application. However, one thing that I think is really important when you're doing protective orders is you need to determine whether you really need a temporary ex parte protective order. The reason for that affidavit and that unsworn declaration is to support the court issuing a temporary ex parte protective order, but not all protective orders need that. And what you may be doing is providing information to the other side, the opposing party, that they can use to cross-examine your client at the final protective order hearing. So if you do not need a temporary ex parte protective order, then you do not need to fill out the declaration and affidavit. Who can file a Texas Family Code PO? So there's a list of who can file, and who can file depends on the type of the protective order. So look specifically at the code, and then it's listed here as well. Who can file a Code of Criminal Procedure PO? So that is also listed in Article 7B. And what's interesting is that there's more people who can file a Code of Criminal Procedure PO than conceivably who can file a Title IV PO. Where do you want to file? Where you want to file the application where in the county in which the applicant resides, where the respondent resides, or any county in which the family violence is alleged to have occurred. And then, as Judge Hubbard talked about a few minutes ago, there's also the new transfer of protective order section under 85064. The only thing I want to point out to that is that that new section states that it applies to motions filed after September 1st, 2025. It does not say it applies to protective orders that are filed after September 1st. So in my opinion, even if there's an existing PO or there's an existing SAPS or divorce, you can still file the motion so long as you file that motion after September 1st. But some judges may disagree with that. What's the timing of filing? Well, if it's during a divorce or a SAPSR, you file it in the court in which the suit is pending, or you can file in a court in the county in which the applicant resides, if that's different from where the suit is. And then if you file it after a divorce or a SAPSR, then you can file in the court that rendered the final PO, or you can file it where the court would have jurisdiction to render a PO if it's in another county. How do you give notice to a respondent? Well, you need to serve by citation. Can you use TRCP 106, the alternative service? And our courts have said, yes, you can do that because the Title IV says that you use citation and you follow all the TRCP rules for citation. That includes 106. Temporary ex parte protective orders, you can ask for them under the family code if there's a clear and present danger of family violence. Like I said before, the affidavit is not for the final hearing. It's for the granting of the temporary order, so consider whether you need it. And then if you want to file an ex parte PO under the Code of Criminal Procedure, the procedure is the same as Title IV in filing it. However, it's clear and present danger of the list in 7B being 7B001 being committed against the applicant, and it now includes the clear and present danger of burglary as it falls under that section of the penal code. Kick out orders. This is kind of a temporary ex parte PO with oomph. It removes someone from a residence. The most important thing to know about this is that you can't just do this on an affidavit. You need to go before the court, and the court can contact the respondent to allow them to come in and be present to counter why they should not be kicked out of a residence. And then I spoke briefly about the transfer of the protective order, so I'll move on from that. There's some additional types of protective order relief that you can get in addition to the standard language that we see about prohibiting contact, prohibiting harassing behavior. And so some of that additional relief that you can get is, and this is any requirements of an order that can apply to any party. So the court can prohibit a party from removing a child from the possession of a person or from the jurisdiction of a court. The court can grant exclusive possession of a residence. The court can give a parent of a child periods of possession and access. The court can order support for a party or child support if the person ordered has an obligation to do so. They can award to a party the use and possession of specified property. They can order a respondent to attend BIP and counseling. They can separate the wireless telephone service. And then there is under the Code of Criminal Procedure, the additional relief is much, much broader than Title IV. The court can really order the alleged offender to take any action that the court determines is necessary or appropriate to reduce the likelihood of future harm. There are some notable cases, and one of them was already discussed by Judge Hepburn, Starry v. Etheridge, so I won't go into that one. But the other case that I think is really interesting is Tate v. Landa, and that was September of this year. And that was a Code of Criminal Procedure protective order where the respondent wanted to rescind the PO. And the Code of Criminal Procedure says that rescission of one of the Article 7B POs can only be done by the applicant. Well, what the appellate court found was that because the Title IV allows for a PO to be modified, that this respondent could modify the PO under Title IV, but could not rescind it under Article 7B. So I think that's an interesting case. And then there's some little known facts about protective orders and practice tips. One of the things that I think is really interesting is that the code, Title IV, says that a court must consider a respondent's inability to pay or ability to pay attorney's fees. But our courts have determined that that's essentially an affirmative defense to having to pay fees. It doesn't create a burden on an applicant to show the respondent's ability to pay. And then some practice tips, just remember that TRCP 301 applies to protective orders. You can't get what you don't plead for. So if your client's situation could apply both to Title IV and the Code of Criminal Procedure, plead them both and make sure that you do that thoroughly in the application. Also, make sure you always give your client, after the PO is finalized, a change of address form. I think this gets missed a lot. That PO, if it lists a protected address, it needs to be updated with the court. So if your client changes their address, they need to submit that change of address form. I've got a list of top 10 cases to keep in your toolkit. These are ones that I constantly go back to. However, I'm not going to go through all of them. They are in the slideshow. And I hope that this has been really helpful to prepare you to handle your next PO case.
Thank you so much, Melissa. If you will, Melissa, there's one question in the chat that I think you could probably readily answer, and I think you almost did just in your last few lines in your presentation. With that being said, our next presenter is Lee Joy Tolliver. She is the managing attorney at our Fort Bend office, Abda's Fort Bend office, and she's going to talk to you all about landlord-tenant rights in the face of family violence. Take it away, Lee Joy.
Thank you. Good morning,
And
everyone.
change Judge Bell.
So I want to talk with you all about landlord-tenant rights and how that affects domestic violence survivors. So I've got a little fact pattern so that I'll share that with you all so that we can take a look and see what is happening in the lives of Fred and Wilma Flintstone. Okay, next slide.
Sandra, are you able to advance the slides?
Okay.
Did
So
it advance or no?
no, we're good here. Thank you. So the objective of this presentation is to get you to understand common concerns that victims of family violence have with respect to various landlord-tenant issues. Additionally, my goal is to allow for you to understand the remedies that are available to them so that they can break a lease due to family violence, and also to become a better equipped practitioner and advocate so that you can assist a victim, whether you are working in a legal aid agency such as myself or you are a private practitioner. Next slide, please. So let's take a look at our fact pattern. So Wilma and her husband, Fred, have been married for 2 years. Fred has struggled with abusing alcohol, and he's gotten violent with Wilma in the past. He's also controlling, and he requires Wilma to check in with him often to let him know of her whereabouts. One night, Wilma and Fred get into an argument after Fred comes home drunk. Fred punches Wilma in the mouth several times, and she flees the home that they share together. She gets treated at the emergency room the same night and is then released. She decides not to press charges against Fred. She stays in the shelter for 4 weeks, and then she's able to get her own apartment, signing a 12-month lease. Next slide. Oh, too far. Can we go back one? Fred finds out where Wilma's new apartment is from the tracker that he's previously placed on her cell phone. Over the next month, Fred sends Wilma numerous threatening text messages and voicemail messages. She sees him in his car circling the apartment complex parking lot when she comes home from work. And twice, Fred has left unwanted gifts on her doorstep with notes asking her to come back to him. Wilma calls the police to report Fred's behavior. The police speak to Fred and they tell him to leave Wilma alone. Fred is not arrested. Next slide. The next week, Fred sends Wilma a dozen roses to her home with a note that says, "I will never leave you alone." Wilma finally decides that she wants to move out of her apartment, but she still has 10 months remaining on her lease. What do you all think might be some concerns of Wilma with respect to her existing lease and her lack of feeling safe at the moment? Tell me in the chat. As we move to the next slide. So some of the immediate concerns that Wilma might have is for her immediate safety, obviously, and wondering if where she is right now is not safe. Is she ever going to have that feeling of security and safety again? Wilma might also be worried about her credit worthiness. Depending on the facts and circumstances that she came into this apartment with, we often see that a lot of domestic violence survivors um, have come from situations where they were financially abused. So maybe they don't have much credit to begin with, or maybe the credit that they already have is not very good. And so even being able to get the apartment in the first place might have been very difficult. And so this might be a concern for her moving forward. She also might be concerned about some moving expenses. Anyone who has moved apartments before, I'm sure that you can recall the expense that comes along with it in both blood, sweat, and tears. Depending on what Wilma's work situation might be. She might need to take some additional time from work in order to move, and maybe she doesn't have the luxury of that. So the moving expenses that she's thinking of might encompass more than just the actual boxes and moving vans, but the time and expense that it's going to take her when she is away from her job and away from her regular responsibilities in order to try to move away from this apartment yet again. She might also be concerned about her confidentiality, what it appears to her neighbors in her new apartment that she's now thinking about moving from, what kind of relationship she might have with the existing management in the building. And also, I'm sure she might be concerned about what she might need to disclose to those who are around and to the landlord if she had not already brought up any instances of abuse or any instances of her past history when she first moved into the apartments. So what can she do? Next. Well, Texas law allows for a tenant to be able to move out of their apartment and vacate their lease early if they have been a victim of family violence. This is under Texas Property Code 92.016. And this provision applies to those that are victims of family violence. And the definition for family violence that is used in this section here of the property code is the same one that we utilize in most of our family cases, which is Texas Family Code section 71.004. Additionally, there is a protection that is provided for those that are victims of sex offenses and stalking under Texas Property Code 92.0161. And so these provisions allow for a tenant to be able to terminate their lease with a 30-day notice or without a 30-day notice if the person that is perpetrating is an additional tenant, co-tenant, or an occupant. And this section allows for the definition of what an occupant is. In order for the tenant to be able to move out of that apartment, there are certain provisions that have to be met. But ideally, once they have met those provisions, it allows for them to be able to move without having any liability for any future rent or any sums that are due for early termination. So no late fees, no additional fees that some apartment complexes or landlords might impose. None of those things are allowed under this statute. It also doesn't matter whether or not the lease is oral or written, as Texas recognizes oral leases. This still allows for the victim to be able to be released from that lease. Now, if the lease has specific language, which I've listed here in the slide, this language is going to allow for the tenant to possibly have some liability for any existing late fees at the time that the family violence occurred that she needed to vacate the premises for. If it does not have this language, then the landlord is unable to recover existing fees. So let's talk about what Wilma would need to show under this statute of 92.016. So some of the documents that Wilma can use to shore up her request to be released from this lease is a copy of a temporary injunction, copies of any ex parte orders or protective orders that have been entered, as well as any magistrate's emergency orders of protection. And we know that the magistrate's emergency orders of protection come about after there has been some sort of criminal offense and arrest of the perpetrator of abuse. And then protective orders and ex parte orders are separate actions that are civil in nature that Wilma has available to her to provide her with some additional protections. And a temporary injunction is something that can also be issued by a family court as well. That is an order for someone to stop doing something they're not supposed to that they're not supposed to do, or to not start doing something that they're not supposed to do. Who can assist Wilma? Well, if we refer back to the fact pattern, we know that she was treated at the emergency room for the injuries that she sustained. So she came into contact with the medical professional. We know that she was able to stay in a shelter for a period of time, about 4 weeks. And in many of the shelters in the area, particularly in Fort Bend, where our ABDA Fort Bend office is located, they provide various wraparound services for all of the occupants there. So she might have come into contact with a mental health provider or a counselor while she was at the shelter. Additionally, the shelter themselves would qualify as an advocate that has the ability to assist and provide documentation so that Wilma can be released from her lease. And the Texas Family Code section 93.001 gives the definition of what someone needs in order to qualify as an advocate under this statute. Additionally, we know that Wilma called the police to report Fred's behavior. So there's the ability for Fred to potentially have some criminal charges that could lead to either a magistrate's emergency order of protection or later down the line, the facts and circumstances to support a protective order or an ex parte protective order. Something that an advocate can provide are details such as this. So under the statute, the advocate needs to provide information to the landlord that explains that they qualify as an advocate under the statute, section 93.001, and that they have been assisting the victim with services. Additionally, they need to conclude and verify that the victim qualifies as a victim of family violence per the statute and the definition of the statute, as well as reference the code that allows for the victim to be able to be released from the lease agreement. Now, if you don't qualify as a advocate under the statute, and for that, that would be if you are a facility or a nonprofit that provides services to victims of domestic violence, or if you are not qualifying as an advocate under that and you're a private attorney, then you're going to refer back to asking the victim who all they came into contact with along their journey. So we talked about that she was able to seek medical attention. So there's a potential for her to be able to get this information from her medical provider. Additionally, anyone that she came into contact at the shelter. And as a private attorney, these are things that you can refer your client to so that they can get the assistance for this additional letter. When can Wilma leave the apartment or leave from her lease agreement? Well, several of these things need to happen at particular times. So if she has an existing order by this time, either a MOEP or a protective order, she needs to provide a copy of that or any relevant documents, such as the letter from the advocate to the landlord. Additionally, Wilma will need to leave written notice of termination with the landlord on or before the 30th day before her lease actually terminates. So she does need to provide it in writing. And written notice can either be determined by the lease agreement. If the lease agreement provides, perhaps maybe there's a portal that the tenants are able to utilize and provide notices or notes or messages to the landlord that way. You could also use good old-fashioned snail mail with a certified return receipt or send it priority. You can also send it via email, but any written notice that's provided to the landlord, unless there's specific notice provisions within the lease, as long as that is received before the 30th day, before the end of the lease termination, then Wilma can comply with this requirement. The 30th day has to have actually passed. So at the time that Wilma is released from any financial obligations under her existing lease agreement, that time period needs to have passed, and she also needs to have vacated the premises. Now, in order to be released from the requirements of the financial requirements of the lease, she needs to have accomplished all of these things, but that doesn't mean that she has to actually stay on the premises throughout that entire time. She can leave, but she would still be financially responsible until she has accomplished all of these items. The times when Wilma would not have to provide this 30-day notice is if Fred was an occupant of the leased premises, or if Fred was a co-tenant with Wilma. In that instance, she would be able to leave and not be responsible financially without even providing that 30-day notice. So what happens if Wilma does all of these things? She provides this information to the landlord, and the landlord says, no, Wilma, you've got 10 more months left on your lease. I'm going to continue to hold you responsible. I'm going to hold on to um, your security deposit, or I'm going to require that you stay on the premises or provide another tenant to come in. What remedy does Wilma have in that instance? Well, the landlord in that instance could potentially be liable for actual damages. So the equivalent of 1 month's rent plus an additional $500 and any attorney's fees that Wilma has incurred in having to force the landlord to release her from her lease agreement. So you want to be careful if you are a landlord and you have a tenant that's coming to you and saying that they are a victim of family violence and need to be released from their lease, because there are penalties that you can face. Additionally, the landlord cannot have the tenant waive their right to terminate. So there can be no provisions in the lease agreement that the landlord has the tenant sign in order to waive that away, that they are entitled to their ability to be able to be released from that lease agreement. So let's talk about some practical matters. So we discussed earlier that some of the concerns that Wilma might have is her immediate or long-term safety. And we talked about some of the ways that she can address that might be through getting some sort of protective orders, whether that's a final protective order that's 2 years or longer, a MOEP, or some sort of injunction in place, criminal charges. But she can also take advantage of a non-disclosure finding from the court that would allow for her contact information to be confidential. We discussed that she might have some concerns about her credit worthiness. Now, the landlord is not able to report to any of the credit bureaus that Wilma has broken her lease, because under the statute, she is allowed to be released from the financial responsibilities under the lease with no penalties. And reporting to someone, reporting to the credit bureaus that someone has a broken lease is most definitely a penalty. That is something that is going to affect her in the long term and being able to get additional housing, and particularly being able to get additional housing without a cosigner. And as we discussed earlier, a lot of victims are coming from situations where they've already been financially abused. And so victims are concerned about being able to secure housing for themselves without needing someone else to assist, which in the past likely would have been the abuser. So one of the things that Wilma can do is she can monitor her credit report. There is a website, annualcreditreport.com, that is free. It allows for every person to be able to get one free credit report with each of the 3 credit bureaus every year. You can do them all at one time, or you can spread them out throughout the year. This is something we at ABDA in my office do with each and every one of our clients so that they can monitor their credit. They can gain some sense of responsibility for their own financial situations. But if there is anything that we catch, additionally, as we're looking for things with respect to family violence, if there's anything that we catch on the credit report that needs to be disputed, then that's something that we can discuss with them. So Wilma can make sure that she is staying on top of reviewing her credit reports to make sure if a previous landlord has reported a broken lease to the credit bureaus, then she can move forward with remedies against that landlord. We also discussed some of the concerns might be with moving expenses. So the crime victims compensation uh, is a resource for victims that allows for them to be compensated for financial burdens that have been placed on them as a result of being victims of any crime, but also particularly family violence. And so there is a wide variety of different types of expenses that might be available for a victim to have reimbursed. And so it's possible that she might be able to get some of her moving expenses reimbursed as part of this crime victims compensation fund. Additionally, for future confidentiality, one of the things that Wilma is going to have to do is provide some sort of address to the landlord so that she can receive her security deposit back if the landlord's going to send it back to her either via check or snail mail. Um, and so some of the concerns that Wilma might have is her confidentiality and privacy moving forward. So there is a program where Wilma can actually apply to get a post office box with the Office of the Attorney General that allows for confidentiality of her actual address, but her being able to still have a place where she can receive mail and other important documents without the potential of her abuser finding out of where she actually is. And so these are all resources that we recommend to our clients on an ongoing basis. And these are resources that could potentially be available to a victim, even if you're not part of a nonprofit agency. One other thing that I want to mention is uh, when Wilma finally is able to be released from this lease and she's moved on to find a new apartment, one thing that we often see our victims struggling with is now they've got to do new deposits. Now they've got to turn on the electricity again. They've got to turn on the gas if they're in a single family home. They've got to switch over the phones. There are fee waivers that are available for these utilities. It's a very simple one-page document that they can fill out. Additionally, they can go back to the client advocate. They can go back to those agencies and personnel that have been assisting them that qualify under 93.001. And it's possible that Wilma might be able to get all of those deposits waived so that she doesn't have to come out of pocket for additional costs as a result of having to move yet again. So as you are going through your time working with victims and survivors, be mindful of these things that are practical everyday things that are on their minds. So when they come to our offices and they're sitting down and they're talking with us, it is our responsibility to make sure that we're also addressing other needs that they might have to face with, and education is a big part of that. So hopefully you have gained some additional insight and things that you can advise your clients on, and also be able to make referrals as needed. Before I stop for questions, I just want to also bring up that this fact pattern was an actual situation that was shared with me in confidence by another attorney who allowed for me to be able to share with you all this. So, family violence is a public health matter. It's not just limited to those that we think are not affected by it. But it's important for us to make sure that we are providing services and that we are being aware and providing information so that we can address the issue of family violence. And as attorneys and practitioners, it's also important that we are mindful to be protective for ourselves as well. And I know that you all will hear about that a little bit later. So with that said, does anyone have any questions?
LaJoy, there were some questions in the Q&A. If you want to, that were relative to your talk, if you want to take the last couple minutes to answer those.
Sure.
Can you get to it? If you can't, I can.
Okay, so I see someone mentioned that the Texas Apartments Associations, they reviewed a lease and it does specifically list these reasons. So generally when you're looking at these boilerplate um, lease agreements, it's going to have some language in there. But it's important to note that even if this language is not in a standard lease, you're not looking at a standard lease, victims still have the ability to be released from those lease agreements as well. Will next question is, will the landlord be held under confidentiality clauses to keep this info from Fred? So if there has been a non-disclosure finding that has been issued, yes, that typically is going to apply to any record-keeping entity, and it could include the previous landlord from being able to issue any information regarding Wilma's new address or new information. What if Wilma has a housing voucher? Will she be able to transfer it to her new apartment? Potentially, it depends on the requirements of her existing housing voucher and what she is able to do with that. If you have any additional questions regarding vouchers, then I would refer you back to who issued the voucher and having questions regarding that with them.
And I believe
Um,
that's all. Let's see, we got some new ones.
Okay.
Oh, yeah. Contact
And
information for ABDA.
So if anyone has any questions in the future, I welcome, send me an email. You can reach me in our Fort Bend office and I will put my contact information back up. I think I had a slide for it, but I'll put it in the, I can put it in the chat as well. But our phone number in the Fort Bend office is 281-207-2312. 281-207-2312. And my email address is my first name, Lejoi, Lejoi, the first initial of my last name, T, at avda-tx.org. So LEJOI at avda-tx.org.
Very good. Thank you, LaJoy.
Thank you.
And our next speaker is Judge Richard Bell, who's the Associate Judge in the 387th District Court in Fort Bend County and also an adjunct professor at U of H. His topic is unique challenges related to disability, language access, and LGBTQ+ issues. Very good. Thank you, Judge.
Thank you, Judge Heppert, and thank the University of Houston Law Center and ABDA for asking me to speak today. We're going to spend the next 30 minutes or so talking about unique challenges that certain individuals face when they're trying to escape an abusive relationship. So we've got 30 minutes. Let's dive right in. The first thing that we're going to talk about today is the unique control factors. One of the things that's typical in all of these family violence cases or intimate partner violence cases is abusers are going to assert various kinds of coercive control over their partners. It can be financial, emotional, physical or sexual, verbal, and then many times isolating the individual. And so these are the types of controls. Many times in cases, you'll see more than just one type of control. You may see several, or you may see all of them being used by the abuser. But in this particular presentation, we're going to look at some unique control factors for certain classes of individuals. So disabled individuals, individuals that have English as a second language or that have difficulty speaking the English language. And then we're going to finish with LGBTQ+. We will also go into some of the reasons why individuals in these classes may fail to report the abuse. And this is important for us to know because in our consultations, we want to make sure we are effective in addressing these concerns and alleviating the concerns if we're able to do so. Because if you're not aware of these issues, then you're not going to make the client feel comfortable that they're going to be safe in leaving the abusive relationship, and they may elect to stay in it. So it's really important for us to be able to spot issue these things and make sure that we're dealing with these in our consultations. And then we also need to be aware of these when we're creating and implementing our safety plans. And then we're going to finish with some practice tips that you can take with you to the office. All right, so looking first into disabled individuals, the control factors affecting them can be just invalidating or minimizing that they have a disability in the first place, telling them that they're exaggerating the disability, those kinds of things, refusing to help with necessary daily tasks, for example, like going to the bathroom. The abuser is the caretaker a lot of times, and then they may say, not help them do those things. Then if there's an accident, they'll use the fact that they had an accident against them. Really what they're doing here is consistent with other types of coercive control. The abuser is trying to destroy the partner's self-worth, their self-esteem. And so they'll do things to humiliate them and make them feel bad about themselves. It can be over medicating or holding their medication hostage. So if they don't perform or behave in a certain way, they tell them you're not going to get your medicine. You're just going to have to deal with the pain because you're not obeying me. You're not doing what I'm telling you to do. So using the medication as a form of control is something that's common. Denying access to healthcare appointments. Many times the caretaker is the person's only source of transportation. And so if they are their only source of transportation, they may refuse to take them to the doctor or tell them they're not going to take them to the doctor if they don't behave or if they threaten to report the abuse. So they'll use that as a control mechanism. It could be also withholding finances. A lot of times they're going to be in control of the Social Security check or the disability checks. And so they will withhold money as a form of control. Destroying or denying their access to disability or mobility devices like wheelchairs or walkers is something that they will do. Harming or threatening to harm a service animal. This is, again, something any time that a partner has some kind of sentimental value attachment to an individual, an animal, or a piece of property, it's right for an abuser to threaten to harm that or to actually harm that. And sometimes service animals can be harmed in these cases. And then just overall using the disability to cause shame and humiliation to the individual. All right, so what are some of the barriers that someone that suffers from or has a disability would have in order to prevent them from reporting the abuse? They are heavily dependent on the caretaker. And so one of the things that's common in these cases is that is their sole source of, that's their sole individual that they can go to meet their daily needs. And so they're afraid if you take away that individual, you report that individual, well, there's not going to be anybody there to take care of them. And many times that's what the abuser's telling them, right? So it's like this has already been brainwashed into their head to think that way, that if I'm not here to take care of you, nobody else is. And so they become totally reliant on this individual And that is one of their biggest concerns is, well, if I report them, how am I going to have my needs met? And so being able to recognize that is important for us. Lack of communication devices. Sometimes they don't have access to communication devices, or the abuser is always with them, so they're never able to actually communicate in a safe environment. Or the abuser is actually monitoring their communication devices, which is also very common. We talked about that lack of transportation, so I won't go over that again. But fear of losing their autonomy. In the event that they turn in their caretaker, they're worried about maybe being institutionalized. I would say probably one of the primary concerns is if there are children involved, that they're going to be concerned, or they're at least going to believe that a court is always going to side with the healthy, physically healthy parent. And so that's something that you need to be aware of. That's going to be one of their major concerns if they have children, is that the court's just going to automatically give the children to the other parent because they have a disability. So you need to be able to alleviate that concern for them, let them know that that's not necessarily the case. The court's going to look at all the factors, not just, the fact that someone has a disability. You also need to, though, be thinking about that when you do present it to court, be able to address that issue, because that will be a concern for a court in the event that she's the primary caretaker. How is she going to provide for the children if she has a significant disability? So have a plan in place for the court as well to address that concern. Many shelters do not accommodate mobility aids. They don't have, ramps necessarily, wheelchair access, walkers, facilities that are comfortable for someone with a disability. And so that is sometimes a concern, is they don't think there's resources out there that will accommodate their needs. And then service providers oftentimes lack training necessary to support the particular needs for survivors of disabilities. And that is true because of just funding sometimes, having the staff available to meet these high needs that sometimes individuals with disabilities have. I mean, sometimes they need almost 24-hour care, and it's just very difficult for organizations to do that. In fact, a recent study showed that only 16% of service providers have a dedicated staff person to deliver services to individuals with disabilities. So it is a concern. It is a need out there. I have a resource page coming up where we have some local resources available to us here in our area that are stepping up and helping in this area. But if you're in a rural county or in a county that doesn't have some of the services, then this may be a very big concern and a legitimate concern that your client has. All right, let's switch gears now and look at individuals that have English as a second language or difficulty communicating in English. What are some of the control factors that an abuser will use in these types of cases? First is failing to file papers or threatening to withdraw papers that have been filed for immigration status. That is going to be a huge concern for an individual if they are in the process of getting status. And I won't spend too much time on that because you're going to have someone speak specifically on this topic. But be aware that that's an issue. Threatening to report the partner to ICE. Many times they'll prevent them from getting a job or schooling. They don't want them to be independent. And so this is a form of keeping them down, keeping their self-esteem down, and then also further isolating them and maintaining control of them because they rely solely on that abuser's income. So a lot of times they will not let them go to work, or they will not let them go to school or practice their English. The other side of that is they'll force them to work, tell them to work, and then they use the fact that they're working as a basis to control them and say, well, I'm going to report you. You're working illegally. And so it's a no-win situation in these cases. It could also be they could also use the fact that they have them sign certain documents like a tax return documents that the individual doesn't understand or is unable to read, and then they use the fact that they signed that document against them. In a lot of these cases, they will hide their important paperwork or threaten to destroy their paperwork, or just hide it or not make it accessible. So when you're doing these kinds of cases, make sure that you let your client know that they need to have the important documents like passports, identification cards, any kind of immigration paperwork, birth certificates for the children, health insurance cards, immunization records, all those important documents. Let them know that they need to have that. They need to know where they are and that they're readily accessible, so that when you are implementing your safety planning, that they get all those papers. But that is a form of control that the abuser will use, is to hide those or keep those papers away from them. In many of these cases, they will threaten to harm the partner's family, or in a lot of these cases, they're actually sending money back to a family that's located in another country, and they're providing financial support for that family. And the abuser will threaten to cut that family off financially if the individual reports them or doesn't behave the way the abuser wants them to behave. And then finally, threatening to take the children away, threatening to have the children deported. These are going to be concerns that you're going to need to address, because that's going to be one of the biggest things on their radar screen is what's going to happen to my children. And so be aware that you need to address that issue with them. All right, what are some barriers to someone that struggles with the English language in reporting abuse? There are several. They may, in many of these cases, the abuser is isolating them, and it's a lot, in some ways, easier to do that, or it's that feeling of isolation is enhanced for a survivor when their family and friends are living in another country. So they don't have a support system here in the United States, or someone that's close to them here. And so that may be one of the impediments, is the just seclusion. They may not be able to work, or they can't drive a car. They many times will not trust law enforcement. They're worried what will happen if law enforcement is called out. So they don't necessarily want to report it, because if they do, they're afraid it's going to disrupt the family unit, that either the abuser will be deported, and if the abuser is the only source of financial income for that family, they're worried about how are they going to provide for their kids, how are they going to meet their minimum reasonable needs if the abuser is deported. But they're also worried about potential themselves being deported, their children being deported or being separated from them. And so that is a major concern. Many times they don't feel like they'll be able to communicate effectively if they do report it. They're afraid the officers may not understand them. The abuser may be more eloquent in their command of the English language, and they worry that their side of the story is not going to get out, and the police will just automatically believe the person that does have a strong command of the English language. So that's a concern. Their immigration status, which we've already talked about. I will say, though, on a side note here, and I won't cover much on this because it's coming up later, but just be aware that the Violence Against Women's Act applies regardless of sex or gender identity. So men and transgendered individuals may seek the assistance from this law. Additionally, VAWA-funded services must not discriminate based on gender identity or sexual orientation. So be aware you may be able to seek immigration relief for individuals that you may not just think of Violence Against Women's Act applying to. Just make sure you're aware that it does apply to those individuals as well. Other barriers are that they don't know what resources are out there, or they're afraid that the resources that may be available to them won't be able to communicate with them. So they're afraid they'll go to a shelter and they won't be able to communicate with anyone at that shelter. Additionally, in some cultures, it is frowned upon to report or talk about family violence. In a lot of these cases, we live in a very diverse area here. In a lot of these cultures, it is taboo to report this family violence. So not only will a survivor not necessarily get the support from their family that you would expect when they report this stuff, but they could actually be ostracized or alienated from their community, alienated from their own family if they report the abuse. So that's going to be another big concern for them. All right, LGBTQ, intimate partner violence statistics. Most studies find that the rate of intimate partner violence between same-sex couples is similar or slightly elevated to heterosexual couples. It's also, most studies show that they have a slightly higher likelihood of sexual abuse than heterosexual relationships. But I would say it's important to note that these studies vary from year to year, and there are so many unreported cases that it's likely that these rates are higher than these studies actually show. Control factors for the LGBTQ relationships. One is they use this homophobia to coerce or control the individual, and that can go both ways. So, for example, if they've got family or that doesn't know that they are homosexual, then outing them in that relationship, outing them to their family can be a major concern, especially if the family is not going to be someone that would be supportive of that. So that can be a huge threat to the partner, is that they're going to out them. But it's also used in cases where the survivor's going to report it, and the abuser will say stuff like, well, you know what happens to gay men in jail, like you're setting me up to have my face bashed in or to kill me. Is that really what you want? And so they'll use the homophobia both to prevent them from reporting it, but they also use it as a threat, that if they come out, they're going to out them. Isolating the partner from the LGBTQ community is another thing that they will use to control them. This goes back to the isolation, but that's a fairly tight-knit community and a source of security for them. And so the abuser will try to take that community away from them. Defining the abusive behavior as normal, or saying that that's just the way LGBTQ relationships are, is something that they do. They could deny them access to hormones, and threatening to take the kids away. This is a fairly common theme through all of these cases, is that the individuals are going to be concerned about their ability to maintain a relationship with their children. This law is evolving, and we're getting more and more protections every year that goes by for individuals in same-sex relationships. But this is very much a concern. Even if the law allows them an avenue, gives them standing, and gives them an ability to go in and prevail at court, they may not know that. And so it's important because they've read about this. There's other states that don't. I mean, this is just something that is going to be a major concern for them. And so just be ready to address that so that you can give them some comfort in knowing they can get out of this relationship and still maintain access or custody of their children. Giving you the control will, that's the slides. You'll have these slides later, but I'm giving you the control will so that you have that in your slide. So what are some barriers that individuals have to seeking assistance in the LGBTQ plus arena? The dangers of outing oneself when seeking help, and the risk of rejection from their family, friends, and society. Many times they're worried about resources available in shelters as well for them. There are certain shelters that won't take transgendered individuals, and so you need to be aware of what resources are out there and be able to address that concern for them. They're going to be sometimes fear of homophobia in the shelters. They're worried that the other individuals living in the shelter won't accept them. And there are, again, we have some local ones here that we'll talk about in the resource page that are going to be available here. But just be aware that that's going to be a concern. And then low levels of confidence in the sensitivity and effectiveness of law enforcement officials. This is very common in these cases where law enforcement just aren't trained in how to recognize intimate partner violence and same-sex relationships. They come out and sometimes just believe it's a argument between two roommates, and so they treat the case differently than they do a family violence situation. And sometimes, you know, the individuals are not comfortable acknowledging the relationship to the police. So it's either the police aren't trained to ask the right questions, or the individuals just don't feel comfortable reporting it. And so be aware of that. I would say one other thing that I didn't really put on the slide, but a lot of gay and lesbian survivors are reluctant to report this because they are afraid that it's going to create a stigma for their community. And so they don't want to do anything that would harm the community in which they live in. And so that sometimes is another impediment, that they're worried that they're going to, you know, reporting this is going to somehow be a black mark against something that can be used by others to just as a basis for opposing these types of relationships. So let's talk a little bit about practice pointers. First practice pointer I would give you is don't be afraid to ask for help in these cases. If you have immigration consequences on the case and you don't handle immigration primarily, then just recognize that you need help. There's nothing wrong with picking up the phone and asking someone for help. It's something that is a good resource for you to do, and it helps your clients. So just get in the practice of doing that on cases where you may need a little help. Just pick up the phone and call somebody. It helps you networking so that when you have future cases like that, you'll know who you can go to and who's well versed in that area. And the same thing is true if you just dabble in family law or you don't do family law primarily. These cases are extremely important to get right. And if you're new at it, it doesn't mean you can't take it. Just maybe get a mentor, someone that's a veteran at family law, and just bounce off ideas with them, because safety planning is so unique in these cases. And it's so important that you do it right. And one of the speakers today is going to talk about technology, and technology is constantly evolving. And there's more and more ways to track individuals than there ever have been before. So it's really, really difficult to do these types of cases and do them effectively. So don't be afraid to recognize that maybe you need help on them. And then if you're going to court, or it looks like the case is going to court, make sure you get your language access coordinator or someone that's there so that your client knows that they're going to have the ability to speak in their native language, and they're not going to have to struggle through English if they have a difficult time with English when they're going to court. And so make sure that you're asking for that help from the court system as well. I would also say investigate resources before safety planning. I think a good idea here is to create a cheat sheet. And I do these all the time as a judge, and so when I have cases that I don't necessarily handle that type of thing every single day, I'll create a 1 or 2 page cheat sheet that gives me case law sites that will help me through that. Well, you can do the same thing as a lawyer. You know, find out what shelters are out there, what agencies are out there that can provide resources for individuals in these types of situations. And then just, you'll have that there. So, you know, okay, I have a disabled individual and this is the person I need to put them in contact with. I have someone in the LGBTQ community. This is the place where I'd like to tell them about. So have that, and then have that available for you so you can pull that up. You know, and it'll let you know like which shelters have access to mobility devices or have that ability, and which agencies have certain individuals that speak certain languages. And then finally, be aware of these additional barriers so that you alleviate your concerns for the client anytime that you can. Some of these barriers are barriers you're not necessarily going to be able to alleviate, but just recognizing them and letting the client know that you understand that that's a major concern and that you're going to do everything that you can to help them overcome that over the course of the representation. So some of the resources available to us here, obviously, ABDA is a great place. You also have the Montrose Center, which used to be called the Switchboard here in Houston, which is very good for LGBTQ. You have the Houston Area Women's Center and the Fort Bend County Women's Center. And then for those of you that are not in this area, you also have the Texas Council on Family Violence and the National Domestic Violence Hotline. I'll give you one more statistic and then I'll open it up for any questions that we have. But the National Coalition on Anti-Violence Programs found that 44% of LGBTQ survivors were denied shelter access when fleeing from domestic and sexual violence. It's 44%. That's a staggering number that you need to be aware of. And again, because we're blessed with a lot of resources here in our area, we don't necessarily have those statistics here locally, but I know there are a lot of people watching that aren't necessarily in an urban area. And I want to thank you all again. Hopefully this helps you in your practice. And let me see if we have any questions. All right, looks like I don't have any questions. So thank you all, and I'll turn it back over to the facilitator.
Thank you so much, Judge Bell. That is an excellent reminder that domestic violence does not discriminate, and there are so many in our community that are impacted and uniquely impacted just by the nature of their particular circumstances. So hopefully this was a helpful opportunity for you all to think about some of the more vulnerable people in dealing with domestic violence. Next up is our Family Violence in the Age of Technology. I want to introduce Stephen Bradley. He is a safety and technology expert, and I think he works at the Our Family Wizard, which is something that most family lawyers are very familiar with. Take it away, Stephen.
Thank you. Thank you very much. And thank you all for attending. Thank you all for having us and kind of interested in what we have to talk about. So we're going to kind of shift a little bit and have some fun. We're going to talk about technology. So my background's in federal law enforcement, specialized in domestic abuse, sexual assault, and human trafficking with a component of technology. This may be scary for some of you, and my apologies. That's not the intent of this. The intent is knowledge is power, so that when that client or that litigant comes to you and says something sounds totally off the wall, like he's got a rubber ducky, he's got cheese pizza, ask the question, why are you worried about a rubber ducky or cheese pizza? They don't call hacker tools. Cheese pizza is child pornography. So if you're saying, hey, he's got cheese pizza in the back bedroom, ask the questions. But that's just a snippet of what we're going to talk about here today. So we talk about technology as a whole. One thing we find a lot is it's very generational. So whether it be the judge you're in front of, whether it be the attorney, the guardian ad litem, the mediator, whoever we're in front of, we may have a generational gap. Let's take my generation, for example, Generation X, one of the best ones. But we grew up with technology. When I went to school and I had a computer class or a typewriting class, it was actually on a typewriter. We didn't have computers. We had textbooks. We actually had to go to school and wrap our books in like brown paper bags and stuff like that and write notes on them because they were heavy textbooks. But today the generations are learned off of tablets and iPads and computers. So of course they're more advanced than we are. All I'm saying is we need to meet our clients and litigants where they're at, not where we're at. Going again back to Generation X, we grew up through all kinds of technologies. Our first cell phone came in a bag, and then we got the Razor phone. We were pretty cool then. But in 2007, our whole world changed, and we got the very first smartphone. The very first iPhone came out in 2007. These devices we carry around in our pockets every single day that we call telephones, these are not telephones. These are supercomputers that make phone calls. But we often forget that. We don't take the steps to protect our data inside our cell phones like we do our home computers or even our homes. But did you realize there's more personal data, personal information in your cell phone today than your own home? Think about it. We all wear these wearable devices, these Fitbits, these Garmins, these different types of devices we wear that track our heart rate, all kinds of different things, O2 sensing. Our messages come to them, maybe from the pharmacy. So we have medical information on there. All kinds of things come to these devices. But we hide behind biometrics and facial recognition type stuff or passwords to protect that data. But if we leave that exposed, someone gets access to that, like a partner, in a domestic abuse relationship, or even like a divorce or separation type relationship, we may be able to get access to that information to cause harm. First, let's talk about the difference between a victim and offender when it comes to cyber-related crimes. For the victims, one thing I tell you worldwide, there's a theme that this is often made out to be a mental health crisis. He's crazy. She's crazy. There's no way possibly I can do that. I can't adjust the thermostat. Or can they? Let's think about family law. Let's think about domestic abuse. We've all taken that. We've all started dating someone. We've all done that 20 questions. What's your favorite color? What school, what car did you drive in high school? What school did you go to? What are those? Security questions. We tell people, especially in intakes, do you change your password? Yes. Well, that's great. But if I can answer your security question, I may still be able to get access to your accounts. On the offender side, don't think for a minute these are computer experts. After working with thousands of offenders from around the world, I can tell you that less than 10% have any kind of computer background at all. These are not Best Buy Geek Squad members or computer science majors. These are what we call keyboard warriors. They simply Google, how do I stalk my partner? How do I do this? How do I do that? So the best resources out there for all of us is YouTube and a website called Reddit. I get a lot of content or presentations off of Reddit. Next time you're on Reddit playing around, or if you're not familiar with Reddit, Reddit is a website full of news groups and chats where people talk about different topics. Next time you're on there, type in the search bar, domestic violence, domestic abuse, sexual assault, and you'll find offenders talking to each other. Hey, I got arrested for these charges. How do I get them dropped in my case? Will this work for me? Maybe it'll work for you. So they empower each other as they go. Don't think for a minute you're dealing with any kind of, again, rocket scientist. Today, 99% of all court cases involve some form of technology. This could be text messages, social media, online dating, simply e-filing. There's always be a technology component to these cases today. So we have to consider technology as every aspect of possible evidence, manipulation, and so forth. With AI today, we hear things like deep fakes and voice cloning. That's just a snippet of what we can do with technology. Here's one particular court case, and I'm not going to get into case law. I know that's boring, but that's not why we're here, and that's not my expertise. But I do want to get in this particular case what the judge or the justice had to say about technology as it pertains to the courts today. This is from Justice Heather McGee up in Ontario. And what she says is text messages, emails, and social media postings have become leading sources of evidence across a wide array of criminal, civil, and family disputes. Judges have before them the actual words and deeds of the parties written or posted in the party's own hand. Or do they? In the era of fake news, it should come at no surprise that from time to time, courts will be presented with fake evidence. Accessible technology has made it easier than ever to generate or alter phone calls, text, emails, social media accounts, photographs, and even expert reports in matter of disguise or origin, fakes, or spoofs their intended purpose. That's what we'll spend the rest of our time talking about. How these everyday technologies that we know and love can be a dual-edged sword. Sometimes they're created for good, but sometimes they can be used for harmful things. Now, before you go throw your phones away at the end of this class, please don't do that. Call me up. I'll give you a big hug. We'll walk you off the cliff. Technology is not the problem. Technology is a tool. But the problem is, as fast as technology changes and grows, laws cannot keep up with technology. And every time we come up with ways to patch vulnerabilities, bad guys come up with ways to make us more vulnerable again. I'll give you an example. Something happened to me. It still kind of sticks with me. It happened a couple years ago now. I was teaching a class down in Miami, Florida, the AG's office. It was an 8-hour class. And we came back from lunch. This young lady, she raised her hand. She's like, hey, can I tell you a quick story about my 13-year-old son? I thought it was about cyberbullying and things like that, but I was wrong. I said, yeah, what's going on? She says, well, today my 13-year-old son and 2 of his friends, they created an app they want to put on the App Store. They want to sell to Apple and Android and Google. I was like, wow, that's pretty impressive. What does this app do? Well, apparently, if I can get within 25 feet of you, I can turn off your cell phone. I was like, oh, wait a minute. Let me put my police hat back on for a second. How many of you have a landline house phone? I stand to guess probably very few of you. We are a cell phone dependent society. So imagine if an offender had a program on his phone in the pocket of his hand or his purse, pocketbook, whatever, and come up behind you within 25 feet, turn off your cell phone, take away your ability to call 911 or emergency services before they did a home invasion, a sexual assault, or a multitude of crimes. How empowering is that for a bad guy? But unfortunately, these are children wanting to play pranks on their friends in the hallway of school. They don't have the capacity to understand how harmful a technology like that would bring. Remember, we talked about the generations, how they're more advanced than we are, meeting our clients where they're at. The reason why we have so much access to individuals today is because we have these wonderful things known as IoTs, the Internet of Things. Today, we have more devices than ever that are connected to the information highway. Here's just a handful of ones that fit on a PowerPoint slide. These smart cars. It's not just these Teslas and digital electric cars. All of our cars today have some type of computer system built into them. Refrigerators. There are refrigerators out there today. They'll tell you when to buy milk. Doorbells, these Ring doorbell, video doorbell type systems. Watches, again, these Apples, Fitbits, Garmin's we all wear, we know and love. Our phones, these AirTags, sneakers. I heard a TV commercial or a radio commercial rather the other day where Skechers now is offering these AirTag type sneakers that you can track your kids or track somebody through their sneakers. Televisions, smart TVs in particular. If you can push a button on your remote and take you to Netflix or a streaming service, that's a smart TV. It's connected to the internet. Gaming consoles. Game consoles are widely overlooked in court cases. Let's say I have a no contact order. I can't talk to my child, but I know every afternoon when he gets home from school, he gets on a video game like Fortnite. What's to prevent me from talking to my child outside the court's purview through a video game? Coffee makers, pacemakers. Pacemakers is a very interesting case that I worked involving a suspicious fire, where a gentleman supposedly woke up at 1:30 a.m. to his house on fire, and he had to jump from a second-story window to save his life. But during the course of the investigation, we found out that he had a pacemaker. So with that information, we went to him, and he confessed to hire somebody to burn his house down for insurance money because the pacemaker showed 0 anomalies at 1:30 a.m. when he supposedly woke up in a frightened manner and jumped from a second-story window. Streaming services, these things like Hulu and Disney Plus, things we download, willy-nilly, inadvertently. But what do I ask you, what do they all have in common besides the internet? If you want to use these type of devices, what do they all have in common besides the internet? Apps. They all have what's called a companion app that goes along with them to show them how they operate and how they run. Do you want to use your Apple Watch? There's an Apple Watch app on your phone. Kind of controls that. Well, according to Pew Research, less than 9% of Americans actually read terms and conditions or privacy policies. Well, our survivors and victims we work with are no different than that. They're part of the regular population. Most of you are legal professionals. We live and die by the written word, statutes, and laws. How many of you read privacy policies and terms and conditions? I seem to be very few. But these free apps can be harmful. They constantly collect personal data about us and possibly disclose that to different websites that are out there. And this is where the slippery slope begins. This is where these offenders find out personal information about us or even our clients. Let me step out of this role for a second and say, At the end of the day, somebody in that court, somebody in that case is not happy with you. Imagine if I can walk out into the hallway and find out where your kids go to school, where you live, where a map to your house, where your spouse works. It causes you harm. We hear a lot about today in the media about doxing, but that's exactly what that is. With these free apps we download, there's all types of data, not data broking websites out there that disclose your personal information. There's groups that believe that everybody has the right to know everything about somebody. Well, we know privacy is safety. We know that's a horrible thing. But offenders can go to these same websites and find out where that confidential domestic violence shelter is, or where your sister's house is, or where you may be staying because you're trying to avoid me. Here's an example, and I encourage all of you to go to this website. You can do it on your phone while we're doing this. Fastpeoplesearch.com. All you do is put your first and last name in there, in your city and state, and then hit search and see what's out there about you. This is just one free one. Oh, and by the way, this free one was widely distributed on TikTok where, hey, you want to find who your legal professional is, where your judge lives, go here. But you see what's out there about you. I caution you, only click on what's called free details. Where it says sponsored by, don't click that. Only free details. And see what's out there. It gives you a snippet of what these vendors can actually see, not only about you, but possibly about your client or about the survivor we're working with. So what are some cool technologies we see in court today? What's this actually look like? Okay, well, we talked about these wearable devices, these smartwatches, these Fitbits, Garmin's, things like that. Well, there's some good information, good evidence, good data that we can get, particularly in these cases. Like the exercise tracker, the all-day tracker, rather. I can see if you've been active or not. If you're telling me that you were just asleep on the couch and somebody broke in your home or someone sexually assaulted you or whatever, I can see here that you did 8,700 steps. You weren't really sleeping on the couch. But if sleep is in question, there's your sleep tracking. We remember the Murdaugh trial, right? Where he's supposedly asleep on the couch for 45 minutes when his wife and son were murdered. If he had a wearable device, we could have very easily proven or disproven if he was asleep or not. The irony in that case is technology is what actually sealed his fate with a Snapchat, a social media video that he didn't know this son recorded. GPS tracking, GPS mapping on the actual wearable device itself usually stores at least 2 weeks worth of information, both what's called active and passive. Active shows me where you are, passive shows me where you've been. So you may have wiped your phone, but your watch may tell a different story. One of my favorite things to look at in an investigation is that exercise tracker, particularly that heart rhythm data we talked about in that arson case. The heart will tell you what the heart wants, right? We hear that all the time. Well, in family law and domestic abuse, it's no different. I can tell you the second you broke up in that relationship, not the day, the actual second it happened. You get startled, you get scared, someone jumps you, something like that. I can tell you the second that happened too. Here's another example. These are not my words, these are hers. This is Miss Heron. Miss Heron was a mother of 3, and she wanted to join this little community, little 5K, 3K run, whatever it was. So one Sunday afternoon, she went running through a park. And she was wearing a Garmin wristwatch, very similar to what I have here. Well, during the course of her run, she had to use the restroom. When she went in the restroom, there was a man hiding inside there that wanted to sexually assault her and attack her. Now, if I just told that to a jury, some people might say, well, did she surprise him? Did he surprise her? What was really happening here? There might be some doubt. However, when I show an image like this, where her Garmin wristwatch captured the whole attack, it tells a different story. And that's why technology is so important in these cases, because it tells a story. Let's talk about another fun thing, reproductive abuse. We talk a lot about domestic abuse and sexual abuse, things like that, but what about reproductive abuse? Reproductive abuse comes in many forms. This just happens to be a digital form, a technology form. Any idea what we're looking at here? Most of you ladies probably do. This is what is known as a period tracker or a menstrual cycle tracker app for your phone. It's an app designed to track your menstrual cycle. Some of you kind of like, whoa, wait a minute, why are we talking about this right now? But believe it or not, it's not about your menstrual cycle. What's this actually about? What's reproductive abuse have to do with this? It's about your ovulation cycle, when you're most likely to get pregnant. These apps are very easily shareable. You take a shower, you go to sleep, I get access to your phone. I can share it with my phone. You'll have no idea I did that. Or if we're in the same house together, I may be able to see things in the trash, kind of guesstimate within 1 or 2 days and be able to track it myself. But again, why do we care about your ovulation cycle? Because in a lot of states, including ours here in Texas, you cannot file for separation or divorce if you're pregnant. And even if you can, your state where you can, the judge still has the discretion to place a temporary hold or stay on that until they can determine custody, paternity, all those fun things we work with every single day. So this has become a power and control tactic to keep people in horrible relationships. Who's been sleeping in your bed? Huh? How many of you ever seen or done a subpoena for sleep IQ, sleep number beds, these digital beds we sleep on, we know and love? A lot of these cases, have allegations of infidelity. They're very sensitive. I can tell you the weight of the person in the bed. I can tell you the activities they're having in the bed. A lot of them have built-in microphones to detect snoring. They're microphones. Guess what else they detect? If you know the right questions to ask, you'll be amazed at the answers you get through technology. If you or your client or the litigant doesn't have a fancy bed, don't worry, don't fret. We have Amazon. And for $30 US, this 5-star here can be purchased. It goes between 2 traditional mattresses and records the same exact data right to your smartphone. So now when you're away on a business trip or wherever, you can see what's happening back at your home. How many of you lift up your mattress to see if there's a pad underneath there that you never knew was there? Last one we see a lot, airline manifest. Well, who was sitting next to you on that plane when you went on that business trip? So again, technology will tell you a story. This is known as ESI, electronically stored information. This is nothing new. This was legally defined in 2006. Well, what these are, these cool terms we hear like metadata, EXIF data, digital this, GPS that. Folks, don't be scared of metadata. All metadata means is data about data. Every digital component, document, photograph has some form of metadata built into it. Today, we have another concern, this whole AI, these ChatGPTs and large language models, Grok, and different things that are out there. Did you know that there's no legal privilege in search history in ChatGPT? So if you want to actually subpoena someone's chat search history, you can do that. Let's see what this actually looks like. I know a lot of you have this notion. I think I know what this is, or people have told me what this looks like. But I will show you an example of this. So the video I'm about to show you is from now a friend of mine, Kristen Pratt, that horrible thing happened to her. As most of you know, social media is, wildly on fire. Everybody wants to be on social media. And more importantly, everybody wants to be an influencer. So we get these random friend requests from people we don't know, but we want, this large friend list, because it's all about numbers of likes, numbers of friends, right? So you click on these inadvertent friend requests that you may or may not get. That's unfortunately where we live today. But let's see what happened to Kristen. Let's see what this looks like in real time, then we'll talk about it.
It seemed like a harmless friend request. But with that one click of the mouse, Kristen Pratt opened the door to a nightmare.
We need to talk face to face, or I'm gonna be dead!
And set in motion a 2-year ordeal that placed her in constant fear for her life. Kristen was a college student in Florida when she was contacted through Facebook by Patrick Mashoni, a classmate from high school, living in the same town, looking to catch up.
I didn't even notice he was in the class with me. It wasn't until later when I went to college that I got a Facebook message from someone who said they were in this class, and that would be Patrick. First couple of messages were great, just like 2 friends or 2 people just catching up. Then after the first 3 or 4 messages, things got excessive. The messages got very weird.
Why do I like you? I don't know. Because you sat in a class and did this. I have no idea why I like you. I don't even know you.
When this starts going on, you're just kind of thinking, all right, it'll go away. But it doesn't go away. It just keeps going and gets worse.
I've been sent on a mission to make Kristen Pratt feel warm and fuzzy.
Kristen knew she needed help.
And when I first called the police, they said, well, does he know where you work? And I said, no. And they said, does he know where you live? And I said, no. And they said, nothing we can do. And they left.
Email me today. It's up to you now. Save your own life.
The cyber stalking intensified.
You don't want me for life, Kristen Pratt? That's a very, very unwise decision.
Many of his messages involved twisted fantasies.
I want to tie your wrists together, strip you naked, secure your arms above your head, blindfold you.
Other posts made Kristen's blood run cold.
Don't make me do something stupid.
She finally got an injunction.
Did he ever abide by the injunction?
No.
Whatever you want, whatever makes you happy, that's what I want.
It didn't matter how many legal things I did or anything. He just saw it as an obstacle in his way that he had to overcome. And he would overcome them every time. He would just be like, hey, I'm here.
I'm here, I'm not going anywhere.
According to him, if we're supposed to be together, none of this is wrong.
All right, Kristen, look, all I'm asking, so let me over one night. You can't keep ignoring me. You can't.
Mashoni started showing up at Kristen's work and on the campus of her college. Desperate, she began altering her appearance in hopes that he wouldn't find her.
How often were you changing your look?
Probably once every 2 months, maybe even more than that sometimes.
Ever get up one day, leave the house, and think to yourself, this could be my last day. This could be the day Patrick actually does me harm.
All the time.
Quit wasting my time.
I knew it was just a matter of time.
Look me in the eye and talk to me like a person.
Then an unexpected turn. While on patrol, Sergeant Mark Conway spotted Mashoni with a backpack acting suspicious. Mike Hallfeld from our Orlando affiliate WKMG caught up with Conway.
I thought I had a car burglar, and when I opened the backpack, I thought I would find maybe stolen car stereos or GPSs in there.
Instead, he found Mashoni's camera and was treated to a frightening glimpse inside the stalker's dark obsession.
Oh man, please just listen to me. I never wanted to be mean or say anything mean.
You know, the videos worried me, and he kept referring to this girl named Kristen. I had no idea who she was.
A quick search of Mashoni's record and Sergeant Conway found injunctions, police reports, and Kristen.
I get a phone call from Sergeant Conway, and he's asking me these questions, and he's wanting to know what's going on. And so I tell him the whole story. And he said, this man's gonna kill you. And he said, that's what I've been trying to tell everybody, but nobody wants to help me.
Digging deeper.
Nobody wanted to help her. What does she mean by that? Kristen went to 2 different courthouses, 3 different law enforcement agencies, the local domestic violence shelter in her community, her university counselors, and she was told stuff like, it's the World Wide Web, or it's freedom of speech. We have no jurisdiction on the World Wide Web, or we can't do this. What he was doing was he was taking these videos and posting them in places like YouTube, Vimeo, Vine, in order to send them to her contacts and her friends after she blocked him to basically try to let her know, hey, I'm following you. He was arrested, as you saw there, and he was sentenced to 4 years in prison. He was only sentenced to, he only did 16 months, and he was released for good behavior. But I ask you, is this stalking? Most of you, hopefully, are probably shaking your head. Absolutely, yes. But did you know that Patrick was not charged with 1 count of stalking? He was charged with 42 counts of that violating an injunction or protective order that took her 17 times, 17 attempts to get her very first one, because she was turned away every time. So in the practice of domestic abuse, domestic violence, we have what's called, a DV assessment type thing. So it's an FRT, Fatality Review Team. And that's usually done a femicide or a homicide where, this occurs. But in the process, we sit down all the community partners. Well, we did the same thing with this case. And there was no femicide. She was perfectly okay. But we wanted to see what the breakdown was in the community. Was it the courts? Was it, law enforcement? Where was it? And they're designed not to point fingers. It's designed to build more education. And what we found in this particular case here was that people just didn't understand what stalking, or particularly cyber stalking, actually was. What you see before you is actually a paragraph of several state statutes around the country that talks about, cyber stalking. A lot of us have this misinterpretation that it has to involve some type of a physical threats or the physical act of following somebody from place to place. But that's not true. These statutes are nothing new. They came online in 2008 and were widely adopted by 2012. So it's engaging in the course of conduct. That's 2 or more events. Some states require 3. To communicate or cause to be communicated directly or indirectly, words, images, or language by through use of electronic mail or electronic communication directed at or pertaining to a specific person. To access or attempt to access online accounts or internet-connected home electronic systems of another person without that person's permission. Causing what? Substantial emotional distress. That's it. That is the burden. Not threats. That's just an enhanced penalty. What is emotional distress? It's different for every single one of you. Feeling overwhelmed, helpless, hopeless. If you're getting a bunch of friend requests from somebody or getting some type of online, attacks, I'm sure it's going to cause you substantial emotional distress. Even in Texas, our penal code here says the same thing. Down there, subsection 8, emotional distress. That's the burden. When it comes to technology, we know a lot of these offenders may come from different states, Oklahoma, or different countries even. And that's cool because the federal statute says the same thing. Emotional distress. Don't get pinned up on it has to be a physical act of following somebody or any kind act of a credible threat. That's not what we need. Yeah, maybe a misdemeanor. It's not pretty, but it gives us something to be able to move forward in that. Here's some examples of what I mean by cyber stalking. Think outside the box. So the first one's kind of a given. Sending frightening unwanted messages. Okay, I get that one. But as we heard earlier about unwanted gifts, if I'm going on your Amazon wish list, I'm sending you unwanted gifts in the mail or sending you flowers, that may be cyber stalking because I did an online component. You get a new boyfriend, new girlfriend, I'm going to kick their butt. I go on social media, I start threatening them. Guess what? I just cyber stalked. Spreading rumors about a person. My wife, my husband's biggest horrible piece of trash there is, whatever it may be. You may have cyber stalked. So don't get put into a box about what this could be, what this actually is. It's very broad. When it comes to domestic abuse, this is from the National Stalking Resource Center out of Washington, D.C. They say that 66% of females and 40% of males are stalked by a current or former intimate partner. And for the most part, that's probably true. But as we saw with Kristen and Patrick, they were never intimate. They never dated. She didn't know the guy. He said he went to school with her. But again, she wanted to be that influencer. She wanted to have those friends. And that started that slippery slope. But all the technology we've talked about so far, and this is just a smidge of them out there, still only 1 out of 4 victims report being stalked through technology. Why is it 1 out of 4? Mainly because you're not going to know it's happening. You're not going to see an app on your phone. You're not going to see some type of program. You're not going to know what's happening. The last one they talk about is GPS. Only 10% of victims report being stalked through GPS. We know GPS is everywhere, but I know your clients and litigants tell you, well, they're following me. They always show up at the Walmart. They always show up at the park. They always know where I am. They know my conversations. Again, they may not know exactly how it's happening. But that's where we're going to talk about that. When we talk about separation, we talk about domestic abuse separation, even divorce and separation, just separation in general. The DOJ actually did a study on this. So they said during a 12-month period, 3.4 million persons age 18 and older are victims of stalking. And we know stalking is very underreported. Stalking is used in social norms and social language today. Are you stalking my Facebook? Stalking my Instagram or whatever, the gram, the snap? Don't be a boomer. Anyway, so they even don't say about it. We know again, but again, we know it's underreported. But of that, that's basically 14 out of every 1,000 people. But now when it comes to separation, it's interesting where that significantly increases to 34 out of 1,000. We know that the first 3 months following any type of separation is the most dangerous. One thing we said in law enforcement all the time was stalking is homicide in slow motion. I have never worked a homicide that was not a random act of violence, like a drive-by or something like that, that did not have a component of stalking inside there. And that's why this is so important. Let's talk about the other ways we can manipulate cases. Communication, one of the biggest ones out there. Some of you may have seen this in the news media where this mom here got a phone call from her daughter. Mom, I've been kidnapped. And the guy snatches the phone and says, yes, I kidnapped your baby girl. If you don't pay me $1 million in the next 3 hours, I'm going to kill her. Mom starts pleading with him. I'm not a rich person. I can't do that. He says, okay, how about 50,000? That should have been clue number one, but this is a very emotional situation. You see your daughter's contact information, her name, phone number, picture may be on your phone. You think you're talking to your daughter. If the mom had her wits about her, which can be very difficult to do, she could have hung up and called her daughter back, or got a second phone and called her daughter. It would have called her daughter, not somebody pretending to be her daughter. Today, there are several apps and programs out there, websites you can go to that allows you to manipulate the caller ID. I can put in anybody's name and phone number I want to put on there. Change my voice from male to female. Add background noises like barking dogs or a sporting event to further help mask my voice. And trying to contact you to manipulate you to think, hey, Steve really isn't that bad of a guy. Maybe you should go back to him. Call you as one of your friends or someone else. And it's me the whole time doing it. But in this particular case, when I say there, I can change my voice from male to female. This wasn't Rosie from the Jetsons. This was some kind of computerized voice. This was daughter's actual voice. How did that happen? Well, today with this whole wonderful thing of AI that we all know and love, we now have what's called voice cloning technology. Where all I need, just a couple seconds of your voice or a couple words, and I can actually become you. Last September, I did 90-minute webinar as a female judge from Louisiana. Every word that came out of my mouth sounded just like her. I did it with her permission, of course. But how did I get her voice? Today, most of us are on social media. You might be on TikTok or something like that, or you might have some type of video on YouTube. But if you don't, it's okay. I can still get your voice. This is how I got Judge Oppenheim's, through her voicemail. We're all professionals. Hi, you've reached the Bradley Law Firm. And maybe your voice on there. If I can get access to your voicemail, your voice, I then can put it in a voice clone program and become you. This has become an inmate scam where inmates are now using your voice to be able to get financial accounts in your name, to buy my partner a car or get more canteen. 18 months ago, our financial institutions across the country thought it'd be a great idea to offer voice verification for your accounts. And that's why it's so easy to do today. So how do we fix this? They say have somebody else record your voicemail. Have a loved one, assistant, somebody else record your voicemail. That way it's not tied to you. So if I do try to call and manipulate you, it's not going to be your voice. But phone calls are just one aspect of it. What about text messages? How do you authenticate text messages today? I know your clients litigants bring you stacks and stacks of text messages. How can I manipulate my partner? Again, just like we saw with spoofing, there's apps out there like this one here called iFake. Allows you to have a whole fake conversation with anybody in the world. I can then print this off and bring it to you, or bring it to my attorney, bring it to whoever, my advocate, say this is what they're saying about me, to try to violate an injunction or protection order, or whatever it may be, or to have charges filed. Again, authentication is going to become a necessary evil in a lot of these cases. We have to hire experts to be able to prove or disprove this. But this is just one aspect. Today, all of us are cell phone users, whether it be Android or iPhone, where now you can actually do your own text editing, where within 2 minutes you can fully delete, or 15 minutes you can fully edit that message. Android's no different. Okay, well, I'll use WhatsApp. Again, no different. They all allow you to edit your text messages. So when they bring them to you, are you diligent? Are you slowing down and looking for that word that says edit or period after the word delivered? If that is, that's not the whole story. You actually have to ask for their device back and push the word edit, and it shows you the original message as it was sent before it was changed. Let's quickly talk about trackers. I know we're running out of time. Today, every cell phone manufacturer after 2006 has 2 GPS trackers built into it. One's for emergency services, and one's for like Google Maps, social media, things like that. One can be turned off, one cannot. Just know that when you turn your locations off on your phone is still admitting to locations. Let's first talk about GPS, satellites in the sky. Again, we talked earlier with the trackers, there's active and there's passive. Active shows me where you are, passive shows me where you've been. Most of these keyboard warrior offenders that spend any time on Google researching GPS trackers will never use an active GPS. They'll always use a passive GPS. The reason why is because if I find that GPS transmitter on your vehicle, in your purse, wherever it may be, within seconds, I can tell you who it belongs to because it's transmitting the information via IP address to the bad guy. That's why most will use a passive one. They'll put it on your car. It has an SD card in it, or they'll get the whole unit, go home and download it at 4 a.m. to find out what you did. Well, that's a pain in the butt. It's cold outside, it's raining, it's hot, whatever the excuse may be. So we're seeing a big shift from satellites in the sky to all of you, all of us. It's called crowdsourcing technology. Works off of the crowd. These tiles and air tags, there's several knockoff brands available on eBay and Amazon today. These are nothing new. Tile's been around for over 10 years, but Tile did a horrible job of advertising themselves. They were advertised as track your luggage. Boring. It wasn't until Apple came out with the air tags, they're like, track your partner, track your kid, track your lunchbox. Well, if I can do that, I can track my spouse or my partner. So we start seeing all kinds of reports come available where these people are finding these air tags in like the gas door of their car, coat pockets, purses, things like that. But believe it or not, this is still not the number one tracker being seen in domestic abuse cases today. Any idea what it is? I guarantee most of you probably have this on your person right now or in your close proximity. AirPods or any type of Bluetooth headphone that has a Find My feature, Bose, Beats, whatever it may be. Think about it. If you open your handbag and you find an air tag inside your purse, they're designed to track you. But AirPods were the same exact way. If you find my headphones in your purse, babe, I've been looking for my headphones, not my tracker. Or I may have purchased these for you and sent them up through my Find My friends, and now I'm tracking you or the children, tracking you through the children because I bought them AirPods as gifts as well. It wasn't, however, until this young lady had a story that went viral that we have to step back and look at this in a different way. This is Miss Daniels, and she was a 20-something, young adult in the Nashville area that went to a happy hour with some coworkers on Friday afternoon. There's no creep in the bar. Nobody kind of bothered her. Nobody talked to her. Hey, how you doing? And that kind of stuff. She had a great time with her girlfriends. When she left, though, she went home. She opened her purse to get her keys out to unlock her front door. She found a Tile tracker inside her purse. It wasn't there before she got to the bar. So one thing they can suspect was while she was distracted talking to her girlfriends, some creep walked behind her and dropped this Tile tracker inside her purse. It wasn't there for good purposes. Home invasion, sexual assault, who knows? When this went viral, Apple was the first company to step up and said, you know what? We have to protect our users. It was called anti-stalking features. So now what that means is if you have an iPhone and I put an AirTag or even AirPods in some cases in your proximity, within 2 hours, you're going to get a notification like this that pops up and says, hey, this is following you. But what did I just say? 2 hours. Well, let's just say I'm a savvy creeper and I'm sitting back and I watch and see you have an Android phone. And I know that Apple does not talk to Android. So if I put an Apple AirTag into your purse, you're not going to get a notification. So Apple's like, you know what? We got to fix that problem too. So now after 72 hours, that AirTag is going to start beeping an audible tone. But even if you do get a notification like this, it tells you to click here to play a sound in order to find that tracker. But again, every time these companies come up with ways to protect us, bad guys come up with ways to make us more vulnerable. So in fact, the point, there's several hundred videos today on YouTube that tells you how to remove a speaker from an AirTag so that you cannot locate it. Remember that mental health piece I talked about earlier? She's crazy, he's crazy. No, you're making me think I'm crazy because I know there's a tracker in my car or wherever. I keep getting notifications, but I can't find it because I can't hear it because you removed the speaker. Finally, last year, Apple and Android, because of this, finally got together and came up with what's called cross-platform tracking. So now if you have a Tile, AirTag, doesn't matter. It's supposed to notify you, like what we saw with iPhone, that this is in your proximity. But again, it's still talking about playing a sound. If they remove the speaker, it may not be any good. Last thing we talk about very quickly is because it's the number one program out there, and we have about 4 minutes. It's called spyware, or better known as spouseware. This is a way for me to actually clone your cell phone. And anything that happens on your cell phone, I get an exact copy of it to my cell phone. This problem costs a whopping $7. It's not very expensive at all in order to use this or to be able to use this. So how does this work? So real quickly, this is my dashboard. When I put this on your phone, I log into it, whether it be on my actual phone or in some other device, a computer, tablet, something like that. So I see who you're calling, who you're texting, what websites you're going to. Not that big of a deal. On the left-hand side is all kinds of cool doors I can go behind, including your locations in real time, anywhere in the world that you are. I don't need an AirTag or any kind of GPS. We take our cell phones everywhere we go. We take them to the bathroom. I can set up a geofence. About power and control, right? Today, I'm going to allow you to go to work. But you're allowed to go from our home to your office and home, nowhere else. So what a geofence is, if you go somewhere you're not supposed to be, turn a street you're not supposed to turn at, it sends me, the offender, a notification saying that you're not where you're supposed to be. And that's when abuse and lethality escalates. Here's all your text messages. I don't get the phone number. I get the actual message as if your phone's in my hand. Here's all your calendar events. I see you meet with your advocate, your attorney, law enforcement. I get to be there too. Here's all your photographs and videos, your social media, including that elusive Snapchat that supposedly delays in 24 hours. Yeah, hold on to that one. Here's your browser history. You're looking for a new apartment, a new job, a bus ticket, a plane ticket. Oh my gosh, he's fixing to leave me. Again, abuse and lethality escalates. Here's all your email communications. I don't have to wait for discovery to see what you're saying. I can see it in real time, your email, your lawyer, whoever it may be. One of the number one features of this program is I can remotely activate the microphone on your phone or look at your camera on your phone and hear and see your surroundings. So how do you have a private, confidential conversation with your client? They're telling you that they listen to it. They know everything they talk about, know where they are. It could be spyware. Believe it or not, airplane mode is your friend. If you turn your phone off, your phone is still on. It still runs what we call Q mode. But by putting your phone in airplane mode, it makes your phone a brick. It turns off every single antenna. Yes, you can turn on Wi-Fi and Bluetooth to watch a movie on a plane, but as a whole, it turns off every antenna. So if your client's telling you people are listening to them and following them, I would actually say, hey, let's put your phone in airplane mode so we have this conversation. I think we're out of time. Do we have any questions? Let's see if Q&A here.
No.
Okay, cool. All right, so
people are just saying this is scary.
It is very scary, and that was a disclaimer in the beginning. So I'm only going to jump up to one slide here. So all in all, this is usually a 2-day class. This is something much longer. There's a lot we have not talking about. But again, get comfortable with technology. You're going to hear those things like, pineapples, raspberry pies, rubber duckies, cheese pizza. If you're concerned about it, if they're concerned about it, be concerned too. Ask the question, or you can contact me. Here's my contact information here. If you want to connect to LinkedIn, that's great. My email, my phone number. I'll be happy to walk you through these cases. Do a lot of expert testimony, expert consulting with both clients and law firms. So feel free to reach out. So thank you all again for attending, and thank you, Judge Hepburn, as well.
Very good. Thank you, Mr. Bradley. That was great. And you could take a picture of his last slide here if you wanted his contact information. Except then it's on your phone. I don't know.
Maybe.
That could be scary. Thank you, sir.
Thank you.
So next we have Josephine Sagwe. She is let me get it correct, Director of Immigration and Civil Engagement for Baker Ripley, and she's going to talk about the intersection of family violence and immigration. Go ahead, Josephine. Thanks.
Thank you so much, Professor Hepburn. I am so excited to be with you today. A lot of times I'm probably the scariest person on a panel, but I'm so glad that I'm going after Stephen. Maybe I'm not this time. So we're going to be talking today about the intersection of family law. But thank you, Stephen. That was really, really great and helpful information for all of us to have. But my portion and during my time, I'm going to be discussing the intersection of family violence and immigration. Today, we've had a number of great speakers able to discuss the trauma, the harm that comes as a result of family violence. But something that sometimes we don't think about until it happens and it's before us in our offices is this. What happens when an individual does not have immigration status? Or even what happens when a person just simply is not a citizen? Before I start talking about some of the forms of relief and the ways in which you might be able to point that person in the right direction, I first want to discuss even the idea and concept of immigration status. If you are a US citizen, that means one of two things. Either one, you were born in the United States, or two, you are a naturalized citizen of the United States, meaning you were a permanent resident through an application process, then you were able to become naturalized. Yes, there are a few other ways, but for simplicity, I'm just going to essentially say that there are two ways. Outside of that, any other person who is here in the United States is someone who is potentially at risk for being placed in immigration court, who is sometimes at risk for being placed in a detention facility. And that is something that I think some people don't realize, because you might think, okay, what about permanent residence? It's permanent. It literally is in the title, right? Well, no, permanent residency does have to be renewed every 10 years. And essentially every 10 years, the United States government gets to decide whether or not you can continue to be a permanent resident. And even as a permanent resident, it is possible for you to end up in removal proceedings, for you to end up in immigration court. And because of that, we want to have an idea of what that person's status is. It is important in order to be able to advise them correctly. I know many of you are probably family law practitioners, so immigration might not be your area of expertise, but being able to identify an issue spot, just like so many of the speakers have said today, is going to be incredibly important, because many of the people who are coming to you, they don't know what they don't know. A lot of the forms of relief that I'm going to talk about today, they're not as popular. They're not things that we hear about in the news as much. And because of that, it's important for you as a legal professional to be able to point someone in the right direction. It might not mean that you are able to do that case for them, but if anything, you can provide them with a referral that could really help their life. So what are we going to discuss today? We're going to discuss possible forms of relief, emphasis on possible. There are, unfortunately, in my time today, I'm not going to be able to talk about all of the exceptions and the things that could potentially prevent someone from being able to get each of the forms of relief that I'll discuss, but we'll talk about those. And also we'll talk about some additional considerations anytime you're working with someone who does not have immigration status or simply is just not a US citizen. Here are some of the possible forms of relief. A little bit of a spoiler of what I will be discussing. We'll be discussing VAWA, U visas, T visas, SIJ, that is Special Immigrant Juveniles, and asylum. So for VAWA, many of you probably have heard about the Violence Against Women Act. This is such a landmark piece of legislation that was really able to help so many individuals in a variety of areas. This is something in which the United States said, hey, we as a country, let's unite together and get many different areas of expertise together to fight this issue that we're having with domestic violence and family violence in our country. Although it is called the Violence Against Women Act, it is a bit of a misnomer, because it does not simply apply to women. It applies to all people. It applies to men, children, parents, everyone. It applies to everyone. This is going to be incredibly important when you are talking with someone who has a partner who is a US citizen or who is a permanent resident. The first thing that you want to think about would be VAWA. So let's talk a little bit more about it. VAWA is designed to be able to help individuals who typically would have been able to obtain their permanent residency through the family system. Many people are familiar with the idea of, oh, I just simply want to petition for my family. I want to file their documents. I want to do their paperwork. Whatever terms they may use, that is something that we typically are aware of. In a happy, normal, healthy relationship, you're going to want your partner, your children, your parents to be able to be in the same country as you. Well, when the situation is not healthy and abuse is there, sometimes immigration is one of the things that is used to control. And so they won't file for their petition. In fact, they may threaten to call ICE, to call immigration on the person. So in these situations, this is where the immigration portion of VAWA becomes incredibly helpful because it puts the power back into the hands of the person who is the survivor. And they are actually enabled to be able to file a self-petition without their abuser. Okay, so this is incredibly important and transformative in the lives of many individuals who were maybe simply relying on someone who was being abusive. So what are the requirements? Here are some of them. In the interest of time, I won't go through all of them, but note who can qualify. In terms of if you as a family practitioner are going through things, you don't need to know and be able to tell someone, yes, you are eligible. I think it simply is enough to be able to say, I think something might apply for you, or something might work in your situation. I think you need to speak with a good immigration attorney about this. But in most situations, if the person who was the abuser was a US citizen, then they may be able to qualify. So we're looking at two things. We want to know whether or not that person was a US citizen or a permanent resident and what their relationship is to the survivor. So we're talking about spouses, children, and parents. Unfortunately, those are the only relationships that would qualify for VAWA. Unfortunately, things like maybe an aunt, a nephew, a grandchild, grandparent, those would not qualify for these, or even a sibling. So something I do want to be able to note that on terms of who can qualify, we have parent of a US citizen, but we don't have parent of a permanent resident. Unfortunately, that is not a typographical error. That is not something that I forgot to put in. If you are the parent of a permanent resident, unfortunately, VAWA would not qualify for you. So we're talking about all these situations in which typically in the normal family visa system, someone would have been able to file a petition for that individual. So, and then now, because of the abuse, that person has the power back in their hands. They're able to move forward. With VAWA, what do you have to show? You first have to be able to show that they were subjected to extreme cruelty. That is there's a very high bar and a high evidentiary standard for VAWA that can be difficult because, as you can imagine, and so many people have already discussed, sometimes the abuser has a lot of the power and control in terms of maybe it could be phones, it could be documents, passports, and things of that nature. And so it may be difficult to even show that they have been the victim of that abuse. Also, we're looking at good moral character, good faith marriage. If we were talking about a spouse, obviously that's not going to be the case in situations where the abuser was a child or parent. Then we're also looking at cohabitation. Another something that I would want us to be able to think through would be special immigrant juvenile status. So this would be a classic situation for this is when you have a child who is under the age of 21, who has been abandoned, abused, or neglected by one or both of their parents. In situations like this is something that the special immigrant juvenile status might be able to help. It does require findings from the family and juvenile court. So when both myself and Professor Heppard were in the clinical program, the immigration clinic worked with the civil clinic a lot on these cases jointly because there is that separate family juvenile court section. And once you get certain findings from the family court, certain findings from the juvenile court, you can then take those to the immigration side to what we call USCIS, that is the United States Citizenship and Immigration Services. You're able to take that, and then if they are approved, then they will be able to have this special immigrant juvenile status. So essentially, this is you have a child maybe who was abandoned, a child who was neglected. They go through this process. They're able to get certain findings from the family court, but they have to go into the family court they can't just simply say, I want special immigrant juvenile status. Instead, they are going to go to the family court seeking a declaratory judgment, maybe a SAPSER, a suit affecting parent-child relationship. They go in there for that, and then they will ask the judge to make certain findings. The findings are going to then be relevant to the immigration case. Once the judge has those findings, they are then able to go to USCIS, get approved. Then they are someone who has that special immigrant juvenile classification. And after that, they actually can file for adjustment of status, meaning apply for permanent residency when a visa is available. So it tends to be really helpful. And again, these are some of the different requirements for SIJ. They do have to be under 21. However, when we start talking about the family courts and the valid juvenile court order that is going to be necessary, really we need under the age of 18 here in the state of Texas. So that's something to note as well. When you have someone who is a child, one of the first questions I ask is, okay, how old are they? Because if they're 17, we really need to get this process started because the time is ticking and time could be potentially running out. They also need to be unmarried. And so this is going to be especially applicable to maybe some of those older teens that you're working with, making sure that they are unmarried, even because they might get the juvenile court order below the age of 18, but the immigration process is going on and they're maybe 20, they're 20 years old and it hasn't gone through yet, they could potentially get married, right? That in terms of their SIJ process, that you wouldn't want that to happen, okay? So then we have here for the U visa. The U visa is going to be for those who typically maybe VAWA would have been a good idea for them. However, the only problem is that their abuser was not a US citizen, their abuser was not a permanent resident. And so in those situations, that's when we start looking at the U visa. The U visa then would be really helpful because they're not going to be able to go through with VAWA. So this is available for individuals who have been the victims of certain crimes here in the United States. Note that it has to be here in the United States. It could not have been abroad in their home country. Instead, needs to be here. The U visa is incredibly helpful because if you are someone who has been the victim of a crime and you are helpful in the investigation or the prosecution of that crime, then you are able to go through the U visa process and potentially be approved for it. This is incredibly helpful to even to law enforcement because it helps and aids their ability to investigate and prosecute crimes. It's another thing, it does further humanitarian interest because it protects the victims of those serious crimes. So the requirements, one, you have to have suffered substantial physical or mental abuse. This is something that I know in my practice I've used several times where there is someone who was abused, was the victim of just severe abuse. But again, their partner was not a US citizen, was not a permanent resident, and therefore was not able to qualify for VAWA. They do have to possess the information concerning the criminal activity. They do have to have been helpful or currently helpful and likely to be helpful in the future. And they need to receive certification from a federal, state, or local law enforcement authority. And again, the criminal activity must have violated the laws of the US or occurred here in the United States. So when we're talking about something that occurred in home country, that's not going to be covered by the U visa, unfortunately. Something I wanted to talk about because it's like, okay, wait, if the crime happened in another country, what happens? Is there no form of relief? Well, not necessarily. Potentially asylum is going to be helpful for them because asylum, whatever persecution that took place, it actually must have taken place outside of the United States. With asylum, we're looking at someone who either has been persecuted in the past or has a well-founded fear of persecution in the future based on a few different factors, a few what we call protected grounds. So that would be race, religion, nationality, membership in a particular social group, or political opinion. Those are going to be things that we're looking at. Asylum is very, very difficult to be able to get. There are two ways that you can get asylum. Either it's going to be one, affirmatively, or maybe you're in the United States, you came in on a visitor's visa or a student visa, and then you apply for asylum and affirmatively avail yourself of this system. The other way is going to be defensive. And what you could do is you could potentially present yourself at a port of entry, or upon being detained, you could be able to state that you do have fear of going back to your home country, and then you would be able to go through the immigration court process seeking asylum. Unfortunately, our asylum approval rates here in Houston are incredibly low. In some some courts, it can be, in terms of the negative decisions, the no's, it could be as high as 90% of the cases that come before them are no's. So it is not something that is easy to get, but it is something that is, I think, definitely worth considering for individuals who were victims and who survived a domestic abuse and family violence in their home countries. So here are a few of the bars to asylum. When it comes to asylum, again, it is incredibly complicated. At the University of Houston Law Center, we do have a course, a semester-long course that talks about asylum, and I'm not talking about it in a few minutes. But when we talk about it, there are certain things that can bar someone to asylum. These are a few of them. And so if someone has gone through, is going through the asylum process, but one of these things applies to them, then suddenly they would no longer be eligible to apply for asylum. And so these are all the things that immigration practitioners will consider while they are filing a case and maybe even deciding whether or not to file a case for an individual. The T visa. So the T visa, this is not going to be as useful maybe for a lot of your clients, but I still wanted to be able to note it because with the T visa, this is for those who have been the victims of trafficking. And it is possible, right, that you could have someone who was brought into the United States for the purpose of being tracked, and there could be a family violence piece to that. And so that's why I wanted to be able to note it so that we have it available to us and have it in our almost in our Rolodex of possible forms of relief that could be available to an individual. So the visa is available for victims of human trafficking. This is going to be, you have to have been subject to severe trafficking for the U visa to apply to, excuse me, for the T visa to apply to you. When we talk about severe trafficking, we're not just talking about sex trafficking. I think sex trafficking is maybe the more known form of trafficking, but it's not the only type of trafficking. In addition to that, there could be involuntary servitude, there could be debt bondage, there could be slavery. And if any of those situations, especially if there was, in the context we're talking about, there was a family violence situation, this could be something that we could be able to consider. The trafficking must have happened in the United States. However, it's possible for maybe it happened first in the home country and then continued in the United States and being able to show that. Then we have that you do have to have complied with reasonable requests from law enforcement involving this, and that they would suffer from extreme hardship if they were removed. So the T visa, again, very helpful, could potentially assist individuals who are the victims who have survived family violence. With the T visa, like the U visa, what you're able to get is a work permit and permission to remain in the country for 4 years under T non-immigrant status, and you are eligible to apply for adjustment of status after 3 years. So with the T visa and the U visa, all of these really, if you are able to get approved, it does put you on this path to citizenship. And so what it is, it's the ultimate, making lemonade out of lemon situation where there was this bad, terrible thing that happened, but as as a result, you actually are able to get on this path. And I will say that a lot of clients that I've had in the past, they struggle with that because they don't want to feel like they're benefiting in some way from something that had happened in the past. But what we kind of talk about is that these are things that are available to you that we have written into our policies and our laws that say that if you were someone who survived these types of this type of persecution, these types of crimes, that there's a way for us for the system to be able to help and assist you. So I wanted to talk about a few additional considerations that might come up in some of these cases that if you aren't used to working with people who are not US citizens, you might not know about. So first, let's talk about crime. So typically, if you're working with a US citizen and that person is then arrested, that's not an exciting moment, but potentially they could be arrested, the charges could be dropped, they might not even go through any prosecution. Well, if the person is not a US citizen, it is actually possible that for that person to be arrested and while they are in jail for an ICE hold or an ICE detainer to be placed upon them. And what that means is that it gives ICE the ability to be able to transfer them from the jail to a detention facility. And in situations where, in a lot of family violence situations, right, where maybe someone is arrested and then maybe that person does an affidavit of non-prosecution or something of that nature, unfortunately, it doesn't even really help in the case of an immigrant because that immigrant is still the ICE has still been notified of that person's presence and has the ability to place them in a detention facility. So the reason why I discuss this is because something that is important to emphasize and underscore with clients is that unfortunately, if you are not a US citizen, that means that you're not going to be able to do some of the things that maybe your friends are able to do. I have this conversation, especially with teenagers, a lot, because you might not realize it, but you have so much to lose. Maybe someone else, they're like, oh, it's just going to be a slap on the wrist and I'll be able to move forward. But when you are someone who is still in this immigration process, it may mean pretty much the end of your case, because even as a permanent resident, if you are arrested, it is possible for you then to be placed in immigration court in removal proceedings and to be detained and deported from the United States. So, again, being able to emphasize the importance of, in all cases, we want people to avoid any type of criminal behavior or anything that could lend itself to it, but especially with immigrants, right? And that means a lot of things. So it could even be making sure that you're driving under the speed limit, that you update your registration and your tags. It could mean that just in a variety of situations that you are making sure that you don't do some of the things that maybe some other people are able to get away with. You don't do any of those things because you know that if you are arrested, that could trigger that ICE detainer, that ICE hold, that then could result in you being placed in detention and just a number of things that happens after that. So important to note that. Social services, another important note because there are a lot of social services that I think more of us are being made aware of. I think the legal field and the bar here especially here in Houston, is working more hand in hand with social services, which is amazing. But the only problem is that there are certain social service organizations that are primarily funded by federal organizations or federal funding, and they technically are not allowed to be able to provide their services to those who do not have status. And so when you are maybe making referrals for someone to talk with someone, that's something to be able to note. Note the people who would be able to help them and the people who would not be able to help them. And even maybe to be able to say, oh, hey, I know you guys wouldn't be able to help them, but do you know someone who could? That's going to be important to note. Another thing I wanted to quickly note, naturalization. So there are some people who they might stay in, especially a domestic violence situation, because they're saying, I want to become a naturalized citizen of the United States. But the thing is that, yes, if you are a permanent resident, after 3 years, if you are in a happy cohabitating relationship, you can apply for naturalization. Yes, that is the case. But at the 5-year mark, you could be able to do it on your own. And so that is something for people to note, that someone does not need to stay in an abusive relationship simply because they believe that that's the only way that they're going to be able to move forward with their naturalization. They actually could be able to do it on their own if they just wait 2 more years. So I wanted to be able to note that. Okay. Now, that's the end of my presentation, but I wanted to leave some time just in case for some questions if we had any.
And we do have a few questions. Are you able to open that, or you want me to? Because it might
Yes,
be
I
easier for
am.
you. I'm going to let you read the question and then answer it. Because I
Yes,
think these are
so
ones you can do.
perfect. So, great question. What can be done if the judge denies the SIJ findings? I have had that happen in other cases at my last job. Custody was given to mom, though. That's something that does happen, and we had that happen in the clinical program as well. Sometimes the judges might feel that they're almost granting immigration status, and because of that, they don't want to be able to move forward. Unfortunately, something that you could do is, for instance, if you first did it as maybe like a SAPSR case, maybe being able to do it as a declaratory judgment or something else and find it a different avenue to be able to get it before another judge, that might be something that you can do. However, yes, unfortunately, that could be the end of the SIJ process in some cases because the judge refuses to be able to deny the findings. And Professor Hepper, did you want to be able to state anything on that?
Well, the only other thing I was going to say, this is where you need to know your judge in whatever county where you are, because typically there's a reputation out there for different judges. So you have a sense of who will give you the findings and who won't. And sometimes you try to look for either a different kind of court or a different county where you might get a better outcome.
Exactly.
Very good.
So
Go ahead
another
on the next.
question, what are factors for court to detail the best interest not to return to their own country, especially if never been in the resident country, if over 18 in CPS custody, why not just apply for citizenship? I think in a lot of those situations, being able to do research on that home country, that's going to be really helpful to be able to know what's going on. And I want to make sure I'm answering your question, because you said, what are the factors for the court to detail the best interest not to return? You're simply, again, providing that information. And so that way, then the court is able to say, okay, I agree, it's in the best interest of the child to not return. If they're over 18 in CPS custody, why not apply for citizenship? The problem in a lot of those cases is that they're not able to, they're not eligible to. So they in a lot of situations, they are not permanent residents, nor do they have, sometimes they might not have status at all. And so that's why they wouldn't be able to apply for citizenship, because there's no pathway eligible. The SIJ in some cases is the only path for them to be able to move forward. And I'll answer one more of these questions. Okay, there was a question, can you clarify if they have to stay in the relationship for 5 years to do it on their own? Great question. No, they do not have to stay in the relationship. So that is in relation to what I was speaking about with naturalization. So if you want to become a naturalized citizen of the United States, and maybe after year 1, you start having some issues in your relationship, yes, you could leave the relationship after 1 year and just make sure that you have continue to have your residency for a total of 5 years, and you can do it completely on your own. And they're not even going to ask you any questions about whether or not you are in a happy cohabitating relationship. The only thing that they would want to make sure to know is whether or not you were married to more than one person at the same time. So they do have concerns about bigamy, but they're not going to have issues about whether or not you are continuing to stay in that relationship. Okay. And I think maybe I can do.
Well, you can do one more, or I can let you answer those by typing the answer in.
And I think I'll try to do this one more really quickly.
Okay,
So
that's
is domestic violence a pathway to citizenship when the victim has a criminal record? It depends. Classic lawyer answer, it's going to depend on what the record is. And however, I will say VAWA is much more forgiving than a lot of the other pathways. And so there might be some exemptions that could be possible. And so someone could potentially get VAWA, and then after VAWA, they could become a permanent resident and then become a US citizen. So that could be a path.
Very good. Thank you very much, Josephine. And again, I'll let you, because you can type the answer in, I will let you do it that way. Our next speaker today is Judge Barbara Stolder. And she's going to be talking about dealing with high maintenance clients. As we all know, a lot of times our family violence clients are stressed and just often harder to deal with. Go ahead,
Yes.
Barbara.
Thank you. Happy Halloween, everybody. Welcome. I'm so glad that y'all are here. I am going to try to manage my PowerPoint. Forgive me if I ask for help, because I am not real good at this. So I think I forgot to share my screen. So let me try to do that real quick. And Let's see.
You see the share screen down at the bottom? There you go.
Yes.
There you go.
Is it up? Okay.
It's gonna be up in
Well,
just a minute. It takes a second for it to.
okay. Let's see. Can everybody see? It's not up yet?
No, it's not up yet.
Okay.
Unshare and reshare your screen. There we
Okay,
go. It's up. It's up
It's up?
now. You're good. Yep.
Okay, let me go back, see if I can find my little button here. Da, 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 da. Okay, so when Judge Hepburn and I were starting to talk about topics, this one in dealing with the high maintenance client came about, and it really spoke to me, mainly because I've been practicing law for 22 years. I've also been a mediator. And one of the things that we know is that sometimes we have clients that, especially domestic violence clients, that aren't always the easiest to deal with. And I started listening to Bill Eddy, who is a family lawyer and a social worker, and he helped provide some context on this topic. He calls them high conflict people. You can call them difficult clients, you can call them high maintenance, you can call them high conflict. But the reality is they're all going to have the same kinds of traits. And some of the traits that they have is that they think they know your job better than you do. They think they know the law better than you do, and they don't have a problem sharing that information with you. They also will call you every day persistently, either you or your staff. They ask the same questions over and over again. And no matter what kind of answer you give them in the very best possible terms, they still tend to not get it. Or they're listening for something that they want to hear, and they're not getting it. They are often rude or to your staff or you, or they're very passive aggressive. They have desire unrealistic outcomes based on the facts of their case, and they're unhappy with everyone and everything around them. I want to talk about the law according to your client. We all have heard our clients say something to the effect of, well, I Googled this and this is what Google told me. Or they will say, well, I talked to my mom and my cousin's best friend's daughter had the exact same situation and this is what she got, so I want the same thing. They consult with their friends and family because for whatever reason, they're not trusting you with their process, or they're just not understanding the way the law works or the way their particular situation, an outcome that they may desire is just not going to happen. We know that the reality of people saying, well, I Googled it, or I talked to my friends and family, we know that they are not understanding what is really going on. So at the very beginning, you need to sit down and have a conversation with your client about the reality of their situation. And sometimes people think that, well, we can just go to court and I can just tell the judge and have this conversation with the judge about what, my husband has done to me, and the judge is going to give me everything I want. They have that law and order mentality. And again, we know that court is not law and order. We know that there are procedural rules, that there are rules of evidence that clients have to follow, that we as lawyers have to follow. And they don't often understand those kinds of rules. When I was in law school, my first year property professor was giving a lecture. And one of the things that he said that has stuck with me all these years is law is not a machine. You do not put in a certain set of facts or information and get a predictable result. We know that in the law that facts are going to vary. Scenarios are going to vary. Your judge is going to vary. The law at the time of a particular case is going to vary, and the jurisdiction you're in. And these are telling you repetitiously, and they're asking you the same question over and over again. It's likely that when you interviewed that client and you sat down to sign them up, you did not provide them with all of the information that they needed to understand that, one, what the boundaries are going to be of your relationship, that you will be billing them for each and every call or email that they send, and that there are only so many hours in the day for you to be able to answer their questions. When clients have unrealistic expectations about their case, it's usually because of what I mentioned earlier. They have had a conversation with a friend or family member who has had a particular outcome, and they think that that's the way every case is going to be. And so when they come to you with their particular set of facts, it's extremely important that, one, you don't necessarily have to give them the law, but you have to explain to them the way the law works and that each case is different, and that we as lawyers have a duty to be able to to advance their case in a manner that they want us to and try to achieve their outcome, but we can't guarantee a predictable result, and we can't guarantee what the judge may or may not do in a particular situation. The one thing I don't think that clients understand, and sometimes lawyers don't understand, is that judges are people too. They have their own set of ideas. They hear information differently depending on what may be going on that particular day. And sometimes when you present your case in court, your theme or story or whatever it is you're trying to convey to the judge may not be presented in the way that the judge is going to get what you're trying to do, or the facts of your case may not just play out the way you hope they would. So it's really important that you do not guarantee a result. You don't even hint at a result. And sometimes it's a really good idea just to not even discuss what you think the court may or may not do. It's really important that you let them know that you're going to do your very best, but you don't have a concrete idea of what the judge may do with their particular situation. Again, clients don't understand the law's not a machine. They don't understand that they can't just go to the court and tell the judge what's going on and that the judge is going to rule in their favor. They're often, and I say this, frequently to my clients, you have good facts and you have bad facts. And sometimes your bad facts will outweigh your good facts. And we don't always know, again, what the judge is looking for in any particular case. What I really want to talk about is unresolved trauma or mental health issues. We all know that if you are a victim or a survivor of domestic violence, that you have trauma. Trauma affects people differently, and we can't judge people on the way they act by the trauma that they have sustained. And if we have a client that comes to us with unresolved or undiagnosed trauma, and they are just kind of poo-pooing it, for lack of a better phrase. It's really important as lawyers that we not shove that under the rug, because some of that trauma can affect the way the case is presented in court. It can affect the way they're able to tell their story, and it can affect the way that they're able to communicate, not just with you, but with your staff and with any other person that they come into contact with that may be a part of the court process. If they have trauma and undiagnosed mental health issues such as bipolar disorder or schizophrenia or severe depression, that changes the way that you need to, one, communicate with them and the way that you present their case in court. And so what is really important is that if you suspect that your client may have unresolved trauma, undiagnosed trauma, or mental health issues, you want to suggest to them or give them referrals for additional help. If your client refuses, I think it's also your duty to explain to them that that could affect the way they present their case in court. And it also, if coupled with unresolved trauma or mental health issues, there's also some additional self-medicating, such as, substance abuse, that can affect their ability to achieve an outcome that they desire, such as sole custody or being the primary conservator. A wound that goes unacknowledged and unwept is a wound that cannot heal. It's really important that we all understand that we all have something and that nobody is exempt. And even our own ideas and biases as lawyers can affect the way we deal with our clients, especially those who are victims of domestic violence, because we may not understand why they do not want to accept a particular offer. They may not want to be able to zealously pursue property division, and they may not want the abuser to have certain access to the children. All of those things are things that we need to understand as lawyers, because if we don't, we're going to be looking at this case as a superficial set of facts when there's really much deeper things going on. And it's also a reason why our clients may be acting in a way that we don't understand. They may be difficult to communicate with. They may be asking for things that we believe are outrageous or unpredictable. They may also be silent and may not be able to assist us with what we need to do. Trauma in childhood can, it's one of those things that our clients often have faced their fears alone. It's very difficult to trust the legal process. It's very difficult to trust you as a lawyer or your staff. They don't know you. They don't know how much information you have about their particular case that you may have heard from the other side. And they are often very difficult to, obtain information from. They can become irritable. They can become very passive aggressive. They can become very needy. And sometimes they are looking to you as the lawyer to solve problems that are not necessarily within your control. We say attorneys and counselors at law, but we're not mental health professionals. And often when these issues come up during the course of a case, we're ill-equipped to deal with them because we don't understand what's going on. And we may see these clients as being very difficult or very needy or very unrealistic, when in all reality, it could be their trauma that is acting out. Trauma is one of those things that you may see your clients in the one who calls you over and over again looking for reassurance. It's really important that you recognize when that relationship has become codependent, and that you are able to then, if you haven't done it at the outset, set some firm boundaries and be able to distance yourself and look at your client's case objectively, and not get emotionally attached to their particular case. They may have difficulty remembering everything and they repeat themselves. This can be extremely frustrating, especially in court. Sometimes you may hear things for the very first time in court. And what happens is your clients, after a particular ruling that they don't like, they will blame you. And a lot of it comes from the fact that had they been more open and had they been able to give you information, or had you been able to prepare them for not remembering events or not remembering dates, then it may have resulted in a different outcome. They may project their own fears on you and your staff, and they may not be very cooperative in gathering the information or evidence. And that goes back to that mistrust. They don't trust you. They don't know what information that they should disclose to you. They're embarrassed. They feel like they have taken on the duty of being the person who solves all the problems in the relationship, and they don't necessarily want to admit that maybe they have their own fears that they need to deal with. Clients often put their eggs in one basket, which means that they may call you for every single thing, where they may need an advocate at a shelter. They may need a counselor for their mental health, and they may need a support system such as families or friends, because you cannot be their end all be all. And that again goes back to that codependency. When you have mental health and high maintenance clients, these provide these kinds of situations are the most difficult to deal with. Bill Eddy talks about high conflict personalities. He talks about them in great detail in several of his books, and he's identified these 5 personality disorders as being the ones that are the most high conflict, the most to deal with, and each and every one of them have a different manner in which you should communicate with them. I didn't put it in this PowerPoint, but there are resources at the end of this presentation for you to go and check out Bill Eddy's podcast. He also has a website called the High Conflict Institute, and he has written numerous books on these particular issues. How do you now? We're at the point where how do you deal with these people? What do you do? Well, from the outside, you have to recognize some of these traits, and you have to be looking for them in those initial consultations. And you need to also train your staff to look for them, because they may not see them. They may be just thinking, oh, this is another client. They're upset because they just got served with divorce. But you need to be able from the outset, dig a little deeper, find out if this is a client that is going to be a difficult client, high maintenance client, or someone that's going to be high conflict. You have to decide if you have the emotional bandwidth to take on this particular client. You have to decide if you have the resources. If you are a solo practitioner and you're doing everything, and you may have someone who helps you, a paralegal on a part-time basis, and you get a high maintenance client that's calling you, texting you, emailing you daily, this may not be the kind of case for you. So you really need to think about that. In addition, you need to be realistic in your own expectations about what you can achieve based on the case. You need to set clear and concise boundaries. You need to make sure that your retainer or your attorney contract spills out all of your billing practices, what you charge for, what you don't charge for, and that they are aware that each and every time there is communication with your office, that there is going to be a charge. Often, this is where I see is the most difficult, is that clients will call day after day, they get their bill, and then they're upset because they're being charged and they don't understand. And sometimes they're going to try to negotiate with you to cut your fee. Know your own worth. Know that the work that you're providing is important, and you need to set that boundary that you are not going to let the client dictate to you how you proceed with a case and what you bill on a particular case. It's also important that if you have a client, a difficult client, and you have a conversation with them and you have asked them to do certain things, or you believe you have come to an agreement on how the case is going to proceed, you document that. First, you document every single thing that you do, and you follow up your phone call with written communication. That way, if somehow the client, files a grievance later on, knock, 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 the bar comes looking, you have documented everything that you have done. Okay. Again, I said you need to properly pre-screen, set out your billing practices, don't promise or hint at an outcome. And if you have homework, which I have found with high maintenance clients, give them homework to do. Give them things that they can do and set deadlines for them to achieve it. And that way they will be filling their time trying to do the homework rather than calling you or texting you. Bill Eddy developed, or I don't think he developed, but there are what they call ear statements that help people to de-escalate situations. And these ear statements have been known that when you've got an angry client on the phone or a high maintenance client and they're just yelling, or they're not very happy, that there are things that you can say to try to de-escalate that moment in time. One of the things, or the ear statements, are empathy, attention, and respect. And there's various ways that you can, or various statements that you can use. But one of the ones I like is that I can see you're really passionate about this topic. I want to make sure that I understand. Or you say, I can see that this situation with your husband is very difficult for you to deal with. Please explain to me how I might be able to help you move forward in a better way. And you have to maintain open body language, have a very calm demeanor. And what this does, it kind of dissipates the anger or the frustration. And when the client sees that you are actively listening and also mirroring back to them something that they may have said to you, then you can see that the tone drops. They become more communicative in a better way. It may not be totally without some aggression or anger, but you can see that it does dissipate somewhat. Bill Eddy also talks about communication through BIF. And BIF is I've tried it a couple of times and I think it's working, but he talks about it in his podcast and he also talks about it in his book that it takes time. It is something that you have to practice over and over again in order to really get the hang of it. BIF is brief, informative, friendly, and firm. It's 2 or 3 sentences where you give them useful information on whatever the issue is. You thank them or use words like, I appreciate you letting me know. But you're firm as well, and you say and you want to make sure that when you're firm that you're not being condescending or you're not labeling them as being difficult or something along those lines. And you may also want to give them sort of a deadline for when you're going to disengage. And one of the examples is, if I do not hear from you by X date, then I will do Y. And that lets the client know that sort of the ball's in their court, but you have given them you've attempted to give them the information that they need in order to move forward. But I am going to tell you, it is hard. It's really, really difficult to practice. Takeaways to help make the most of the attorney-client relationship: document your calls, use the BIF technique, set boundaries and keep them, assess whether your client needs additional assistance, make referrals, check your own emotional bandwidth. Don't take what they say personally. And when things do go personal, you have to decide if you're going to stay or go. Recently, in the last 6 months, I had a client that did not like a particular outcome in court. And when we were in the hallway, he proceeded to berate me. And when I attempted to calm him down using some of the techniques, it did not work. And he got in my face. He was very rude. He was loud. He was abusive. And ended up, someone in the hallway ended up calling courthouse security. That is not a client I chose to stick with, because when that client turns abusive or when that client turns personal and when they can no longer control their own emotions, you have to decide if that's a client that you want to stay with. In addition, when you have difficult clients, you have to weigh whether or not you want to stay with a client and risk a grievance, or whether or not you want to proceed. Some of the things, I only have a minute left, but I do want you to know that the Texas Rules of Professional Conduct talk about the attorney-client relationship. And one of the things over and over that I have seen sort of a theme is that you need to respond to your client. You need to be able to zealously advocate them, and you need to do it within the rules of professional conduct. Don't let your client lead you down a rabbit trail that is ultimately going to get you sideways with the rules. The lawyer has the right for legal tactics, but do not let the difficult client take you outside of what your duty is as a lawyer. Finally, I want to remind you of the Texas Lawyers Creed. You can see it at texascourts.gov. When I read this, it really resonated with me that as a lawyer, I am entrusted with a really important job. And my job is to advance the will of my client. But I also have to do it within the rules of professional conduct. And no matter how much money a client pays you, you yourself have to decide if that difficult client is worth it. And that's why I go back to know your own worth, know if you have the emotional bandwidth. And that is the end of my talk. Let me stop screen sharing. Are there any questions? How should you deal with a client where in the course of representation, you find out that your client is the aggressor and you have been lied to? I think, again, as a lawyer, we all have to know what our own personal boundaries are, what we are willing to do for a client and what we're not willing to do. If you're the lawyer that says, I'm not going to represent people, one, who lied to me, or people who are the aggressor, because ultimately that changes the facts of your case, then you have to decide, do you want to stay with this client or do you want to go? And that really is a personal choice. And if for some reason you come across another ethical dilemma during the course of that representation, let me remind you, you can always call the ethics hotline. Okay? All right. Thank you very much. I am going to turn off my video and turn it over to Maisha.
Thank you so much, Barbara. I am going to be talking to you all about something that is, I think, a good continuum from what you just heard from Barbara in regard to dealing with difficult clients. My topic today is in regard to, hold on for a minute, make sure are y'all able to see my screen?
No, we are not.
Not yet.
All right,
Make
let
sure
me go
you
back.
share.
Let me
You
go
have
back.
to share first.
I thought I did, but I might have clicked too quick.
Sometimes it doesn't take.
Let's see here. I'm hold it down a little bit.
There. Okay, it's coming.
Okay.
It's coming. It's not there yet. There we go. Now you have to start your PowerPoint.
Here we go. So
looks good.
Thank you. All right, so my topic today is in regard to attorney safety, and I have some objectives that I hope we can accomplish within the time allowed. Identify some common threats attorneys face in high conflict cases, recognize the effects of trauma and secondary trauma on attorney well-being, evaluate barriers to reporting safety concerns with organizations, apply trauma-informed practices to support attorney resilience, develop safety-conscious policies for workplace and courtrooms, and explore ethical consideration in using civil restraining orders for attorney protection. So before we get started, I have a couple of poll questions that we have baked into this presentation. We've not used this tool today. Hopefully it will work. And I would invite you all to participate in the polls that are being made available. The first poll question asks, have you ever been subjected to physical intimidation by an opposing party, opposing counsel, or client? And select all that apply. The second poll question is, have you ever been threatened with bodily harm by an opposing party, opposing counsel, or client? Select all that apply. I'm going to give you a little bit of time to take those polls. And Christina, let me know when you see.
Yes, I've noted that
results.
many have responded, but if you haven't had an opportunity to weigh in, I'll give it a few more seconds before I publish the results.
All right, so our poll results, 44% of participants who answered the poll say that yes, they have had been subjected to physical intimidation by an opposing party. Yes to being 23% say that they, I'm sorry, 9% say that they have been subjected to physical intimidation by opposing counsel. And 5% say that they have been subjected to physical intimidation by a client. Have you ever been threatened with bodily harm by an opposing party? For this one, we have 14% say that they have. 3% say that they have had that experience directed to them by a opposing counsel, and 4% say that they have had a client threaten them with bodily harm. I'm actually quite relieved by the statistics of this group in terms of more of you have not had these unfortunate experiences, either at the hand of a client or opposing counsel or a party in a lawsuit. I gave this presentation for the ABA a couple of months ago, and I will tell you that statistically, the numbers were higher with a larger group that were polled in that particular presentation. In any event, I hope that that you continue to not have this experience, but if in fact you have, or if you may have it in the future, this this presentation will help to elevate some ways for you to respond going forward. So, attorney trauma and burnout. Lawyers representing survivors of violence are exposed to many sources of trauma, and we all have probably heard of the concept of vicarious trauma, and that's the idea of you having a experience of trauma as a result of hearing about the trauma that your client has experienced, someone who has been either a victim of abuse, sexual assault, or some type of violence, and you have to either hear their story, see pictures of the injuries that they sustained, and that's a part of your preparation in working and representing them. And so you consume some of that trauma through your own direct experience with that survivor. But what we're talking about here is not necessarily something that's vicarious, but actually direct stress and trauma that is directed to you in your role as a representative or an advocate. Unaddressed trauma in this way can lead to burnout and high turnover rates, either if you're working for a firm or in some type of setting where you are required to deal with clients, and trauma or the potential for trauma being directed toward you is a possibility in that work. Burnout reduces case effectiveness and client outcomes. Trauma-informed workplaces promote the retention and resilience and the quality of advocacy that we want to see in our profession. And so what we want to talk about is some ways to get to that place of having a trauma-informed workplace. 1 in 4 attorneys report being threatened or harassed in connection with their work. Before I even show the next slide, I want you to think about what areas of practice you anticipate are the top 4 areas of practice where you might see threats or harassment in work. And just kind of hold that thought. Number 1, good old family law. criminal prosecution, criminal defense, and sometimes general practice. But for most of you who are on this call, probably a large swath of you are dealing with family law and you are family law practitioners. And unfortunately, we are at the highest level of risk for threats of violence and harassment in the work that we do. And this is especially true for family law and legal aid attorneys. And I think part of what was presented in Barbara's session before mine, where you have the ability when you're charging someone to potentially tap down some of their reactive or aggressive pursuit of you, because when they start seeing these bills, they may wind up saying, okay, I need to stop calling because I didn't realize that every call was going to add up to this amount of money. And that might give you a level of ability to sort of mitigate some of that behavior being directed towards you. And that is not the case if you are working as a legal aid attorney where fees are not a part of it. But what are the things that she said in her presentation that would be relevant to trying to assist you in mitigating some of that heightened stress, that interactions that are ripe with tension and just volatility, is to put your clients to work. That is the exchange that you do have at your disposal. If you are a legal aid attorney, you can bake in some really, really important restrictions on how your representation will be provided when you still have to do an engagement, a retainer agreement of some sort, and some of those boundaries can be a part of how you and your client maintain a relationship that's going to be conducive to continuation of care throughout litigation in a high conflict case where there is the potential for a high conflict or toxic behavior that's being directed toward you when you are their advocate. As we talk about this topic, there's a couple of things that I came across in my research that I think might be helpful for people to understand so that you have some warning signs, if you will, in regard to how this potential volatile behavior, harassing behavior, and also potentially violent behavior can manifest and show up. And generally speaking, there are signs before it gets to that point. And so I'm going to talk to you a little bit about these the build up to violence. And here are some of the things that you need to be aware. There's a pathway of behavior: fixation, identification, novel aggression, energy bursts, leakage of communication, last resort, and then direct communicated threat. So what that is essentially this idea that when you have someone who is already volatile or showing signs of violence, and not necessarily to you, but as you get to know your client and you experience some of their mannerisms and their temperament, there might be times where you start to see for yourself some behaviors that will give you an idea of the potential for that person to potentially have that result in them being volatile or violent towards you or harassing towards you. When you have someone who is fixating, and that just means that they will not let that thing go. That's a very clear red flag. And it could be similar again to the previous presentation, where someone continues to ask the same question, hoping that they hear something different from you. And the answer is not going to be different. There's no way that it can be different. And so they are fixated on the fact that this thing is this way, and they have no means past that thing. And for whatever reason, they cannot let it go, even though there is nothing that will be done about it. Another thing is identification. This is more of the idea that you're not relating to them. You're not understanding their particular needs or how to address whatever it is. So when you start seeing someone in a client's circumstance and although you are doing your level best to be their advocate, to give them the counsel and advice that they need, to look at the law and see what might be in their favor, and yet and still they reject you. They don't feel like you're their advocate. I've had clients say that, because I was friendly or, amicable with opposing counsel, in the hallway or in, how I, treat them, that somehow I can't possibly be on their side. And again, when those things start to appear in their communication, those are red flags and those things need to be addressed, but it might also be a sign that this is a buildup. Novel aggression. So they may actually do some passive aggressive things or aggressive things, not necessarily that's completely obvious at the time, but you think about, well, after the fact this thing happened, you kind of go to yourself, I don't like that. I don't like the way that I was spoken to, or I don't like, what's, in this email. This doesn't even make sense. That didn't happen. But you start to see and hear some sort of indication that this person is starting to be aggressive or angry in their manner toward you. Energy bursts, when they just start to continually keep persisting, sort of goes along with that fixation aspect. And then there's the leakage of communication. And I know that probably many of you have experienced this, where now the communication that should be attorney-client privilege, other people are being disclosed to, whether that starts out as somebody on your staff, but then it bleeds into, well, I talked to my mother about this, and I don't think that, once we had this conversation, she said that I should, you should be doing this, or the same sort of concept that was given in the previous presentation. My sister, cousin, daughter had the exact same thing and they got $1 million, and how is it that I'm not getting $1 million? It's you're not doing what you need to do on my behalf. So when you start to have those kinds of things, again, these are red flags. These are opportunities for you to assess whether or not this case, this representation, this continuation of your relationship with this particular client is conducive to what your boundaries, what you will tolerate as a practitioner, and obviously, more importantly, your safety and your risk of harm as a result of these things escalating into something more explosive. At the point where we get to before the leakage of communication, you may have a threat by the client that, you've got to fix this, you've got to do something about this situation, and then ultimately a communicated, clear threat of harm to you. And that could be in the form of actual harm, like physical harm to you, or it could be in the form of a threat to, I'm going to take this to the bar, I'm going to take this to the media, whatever it is, you're now being exposed to threats of harm as a result of your representation and that relationship that you have with this client. One of the things that I spoke to you about earlier is that family cases, criminal cases are typically where we see this type of harmful behavior on the part of a client, and that's because of the intimacy effect. And that's just the idea that the more intimate the relationship, the more likelihood there is for things to escalate, and there might be some threat or of violence or harm. And when we're talking about intimacy, we're not talking about an inappropriate relationship between you and your client. What we're talking about is the fact that when you are dealing with family law, you're oftentimes having to be exposed to the most intimate details of a person's relationship, their life, their lifestyle. And as a result of that requirement in your communication and your communication level with that client, somehow that then equates to you all have a level of intimacy. The same could be true for criminal either defense or prosecution, but it is certainly true in the instance of family law. Just think about what you are working on in a family law case, and that includes, their money, their children, probably the most important things that a person may value in their life. And so that's where we have to be aware that puts us at a more vulnerable situation. The other thing, if you are a family law practitioner who happens to do a lot of high conflict domestic violence representation, sexual abuse representation, or your clients, are experiencing those things, violence tends to find a victim. And so oftentimes within the litigation of family violence cases, the abuser will now use the litigation process to continue to control, to continue to assert coercive behavior, not now just against that survivor that you're representing, but they will do it in the courts itself. They may to some degree do it in the litigation and ultimately to you. So not just to be concerned about your own client, but you have the potential to be concerned about the opposing party who is, in most instances, if you're doing a DV case, already has a propensity for violence. And that violence can ultimately be redirected towards you. So that's a risk that you do need to be aware of. Oftentimes, when we get to the place where threats are happening, it's happening in one of these places. It's either going to be right in person, in your face, either in your office, in a courthouse setting, in a mediation, but it could also occur online, in writing, telephonically. You could get calls. You can get either threats of harm, left on your voicemail, or you may pick up the phone and get cussed out, or it could happen with the third party being the conduit for that threat of harm. But just be aware that once it happens, there's all these different opportunities for threats, and your response may look different depending on how it is happening, whether it's in person versus whether it's online. Also, social media, that's another place where it is happening, or much more now than ever, obviously. Here are some of the things that you can do to help protect yourself. The first thing that I recommend is to have workplace safety policies and to have them written down. And those include how client meetings and communications will occur. What building access and safety looks like within your organization, within your office. If you're a solo practitioner, who can you communicate with in the event that you might have a volatile either client or opposing party come to your house? What are your safety protocols when those things occur? And this can be for a solo practitioner, and I mean literally one person operating a law office, all the way through to corporation or large firm who's handling, these types of cases. What is your evacuation plan? Again, it needs to be written down, and not just written down, but really practically thought out. Another thing is procedure for reporting safety concerns to a supervisor. So if you're working in a workplace, and remember what we were talking about earlier, resiliency, avoiding burnout, having a trauma-informed workplace, where can you go once something has happened? Is there a protocol? Is there a place where you go to? Is there a supervisor who you need to report an incident that happened when you were over at the courthouse? Whether that was the opposing party, opposing attorney, or even your own client. Is there a, hey, this happened while I was in court. This happened while I was at mediation. What is the protocol to report this, to document that this thing happened? And then what are the consequences of reporting this type of behavior? Is this an automatic, we need to withdraw from this case? We need to contact law enforcement. And you actually should be building in and writing down procedures that examine and evaluate all of the different scenarios that might be relevant to the particular situation that you experience or you imagine when you're drafting these and you have not had that direct experience. Emergency response procedures. Who calls the police? Who calls building security? What's the code word if you're in an office space and someone is harming you? Is there a button? Is there a panic button? What happens when you're at court and you have these types of threatening or harmful behaviors? Are you texting someone at the office to notify them? Are you going back in to talk to the bailiff? And again, if this is a larger setting, an office setting, Are these policies and procedures already in place? And are you educating your staff about protocols and things that they can do to respond to these particular situations? Law office safety. Another thing that you can think about is the physical space that you occupy when you potentially, because your clients are going to know where you office, unless you have a virtual, 100% virtual circumstance. They will potentially come to your office, meet you for mediations, or obviously meet you at the courthouse. And you need to be aware of what those particular settings that you interface with. Again, your client, opposing party, opposing counsel. All of these could be places where you meet threats of harm. Is the parking lot well lit? Is it a gated parking lot? Are there security cameras? We had a recent incident at our Fort Bend office. Not one of our attorneys, but one of our therapists was over there after group. She and a number of our clients encountered their vehicles being vandalized after the group. And of course, we had a protocol as far as contacting law enforcement, reporting the incident, and all of those things. But I learned just last week when this happened that there were no cameras in the area where they parked their cars. So that is another something to be reminded of. Like, there are certain places where you might not be able to park because there is no camera there. There is no ability for someone to be able to see or witness some of what happened. They have building security. Was that person patrolling the parking lot when they were coming out of group or while they were in group? And I had to have these kind of conversations with the people who own that particular building. But this is, again, something for you to think about as you navigate through your personal dynamics related to your office setting. Entrances, public entrances. We had the good fortune many years for someone to come and do a safety check here at our ABDA offices in downtown. And the person who did the safety assessment for us asked us to do a number of things that we had not even thought about and had no reason to even have knowledge about them. So, for example, we have eye holes, like to peep through to see if who's out the door. They advised us to change the door peephole. Actually lower it to the right, and there's some safety protocol that is involved with why those instructions were provided to us. And then we took those things into consideration. We have, keypads with codes and things like that on doors. We have rules that say, clients can't walk unescorted. If they are here, they have to be physically with an ABDA employee. So there's all these things that you can do within the scope of your building structure that might help to, again, elevate your safety and your risk, reduce your risk of harm. Barriers between reception and inner office. Again, many, many years ago, we didn't used to have a glass structure that housed our receptionists. All of those things have changed. We have cameras, all over the place. But those are the kinds of things that we attended to with the idea that we want to reduce the risk of harm to our employees and try to make this as safe a place as possible under the circumstances. We annually do a class on active shooter training. People hate it because it feels like, why are we even having to think about that? We've obviously not had anything of that magnitude, but who knows? Who really knows when or how these things happen? And they do happen, right? So we are cognizant of that, and we try to take the precautions that we think are necessary, again, to just sort of elevate the idea of safety for our staff. I mentioned this earlier, but panic buttons, if you have loudspeakers, are there any code words that you can use to potentially advise someone that there is a risk of harm, that you're in an unsafe situation? What does your desk look like? Are you able to get to the door quickly? Is your client kind of blocking you? Think about the dimensions of your law office and how it's set up with safety in mind. Like I said, visitors always have to be escorted. There's no such thing as, I'll just you know, I know where my client, my attorney's office is. I can just walk to their office. I've been here a number of times. That's not how it works. Obviously, checking visitors in and making sure you document who's come in. If you have building security, do they sign in? Do they have to show an ID? Do they have to sign out? So you sort of have an idea about the time and place of their entry and the time and place of when they left the building. Some comparative models. When I was doing my research, I was just thinking about safety from all kinds of vantage points and all types of workspaces. And so, you know, within the medical field, hospitals have code grays and they have protocols for violent patients. Law firms can adopt some of those same practical processes for our safety as well. Corporate HR, mandatory incident reporting. Again, these are things that we can adopt within our law practices. And again, and I would urge this to not be limited to big firms or medium-sized firms or even small firms, even to solos, to really think about what they should have in place to help protect themselves. The judiciary model, so some courts stagger exits and provide secure witness waiting rooms, and that might be true like within the 280th or the protective order court here locally. But when you're in some other jurisdiction, what are the safety protocols for your courthouses? How does it look? Have you examined those things? Is there anything that you can recommend that needs to happen to implement more opportunity for safety to be available to you as you navigate in and out of those buildings? And again, these can go in your policies and procedures. Don't be alone in the office with potentially threatening client. So if you have someone who's already sort of, remember those red flags that we talked about, those warning signs of behavior, make sure that someone knows that this person is coming to the office before they ever show up. Make sure that there's someone on the ready, and potentially maybe you don't have a meeting with them alone. Maybe you meet with them in a conference room in an open space. Maybe someone is sitting with you present at the time, whether it's a paralegal or some other person who is in your office. But think about who should engage with these people when you have heard or seen some of those signs of escalating behavior. Establish the safety meeting location, remove potential weapons, control how meetings will begin and end. Courthouse safety, staggered exits, meeting rooms, buddy system, communication with security. So I've had cases in the past where when I know I'm going to be seeing this particular client and this particular opposing party, I will alert the bailiff even before we get there. Hey, here's what's going on. There was a couple of courts that I had appeared in back in the day in where the sheriff's deputy of Fort Bend, they will walk you from the courthouse all the way to your vehicle based on some of what they see and observe in courtroom dynamics and behavior. So if you think that you might need that same level of treatment, then you might want to talk to the court in advance and let them know, hey, I'm not feeling great about this person. We have to have this hearing today. I'm anticipating the outcome is going to be not great for this opposing party, and I don't know how he's going to behave. So start to think and pre-program what safety might look like under those circumstances. Last but not least is safety at home and online. Remove your information from data aggregation websites. Stephen's presentation was scary enough in that what he was talking about, but understand that that has implications not just for clients doing harm to one another, but potentially doing harm to attorneys who are involved in those cases. Technology has the ability for people to use their powers for good and the ability for them to use their powers for evil. And we obviously need to be aware of it. I know it's Halloween. I definitely don't want to scare anybody, but I do think what Stephen was talking about and what I'm talking about is an opportunity for us to rethink how we think about safety and the work that we do, and try to figure out new ways to make sure that, again, we elevate our safety possibility and reduce risk for harm as much as we possibly can. I'm trying to be cognizant of the time, because since I'm the last person, I need to wrap things up.
Well, you also have a question.
I
If
do.
you go back
Okay.
a slide,
I can.
you had a question about protecting your phone and personal information. Do not list. Yeah, so there's a
Yeah.
question in the Q&A. Do you have any
Uh-huh.
recommendation? No, Is there a way to protect our personal information like home address from appearing on internet searches? So that's kind of goes along with what you have there.
Yeah, so one of the things, there are some ways to remove yourself from certain public facing, for example, let's say HCAD, not disclosing your address or your, things of that nature. There are some things that you can do to actually complete forms and fill out that type of information so that you can be removed, so someone cannot access those things. But you would have to do a individualized security assessment to figure out what exactly is already exposed out there in the internet ether. Because even if you remove yourself, something might be memorialized already, but it's worth doing a deeper dive about your level of exposure in terms of the information that is available to anyone about you. And again, this is just a recommendation that people look at, what can people see about you just by doing a simple search and a free search. And if you are concerned about the things that they can find, then definitely it's something to evaluate and try to figure out what can I do to scrub my name, get that information out of the public ether, because I do feel like it puts me at risk. Some de-escalation techniques. This is just some things that I think are helpful. It kind of mirrors some of what Barbara was talking about before in terms of how to talk to someone, remain calm, attempt to break or recess until a future date. Do not argue, do not hide behind your authority, avoid an aggressive stance, avoid looking or speaking down to an individual, keep your distance, do not touch the individual. Speak slowly. This is that active listening, empathetic listening, mirroring what someone is saying, asking questions that are probing to kind of calm them down and redirect them, or at least reset them about whatever it is that's causing them to get escalated in their emotions. I'm speeding through only for the sake of time. The slides will be available for you all to explore. But normalize conversations about safety, train attorney staff in de-escalation techniques, establish peer support groups for attorney well-being, include safety in onboarding and annual training, create confidential and non-punitive ways to report safety concerns. It is okay for someone to be vulnerable, and it's true that for lawyers. I know that there is sort of a culture where lawyers need to be tough and aggressive, and it almost lends itself to not recognizing that we can be vulnerable and that we could be exposed to threats of harm. And so we really do need to do a better job about creating a culture that recognizes that we are at risk, especially with some of the areas of practice and some of the types of cases that we take on, and then recognize that there is resources out there, and when there aren't any resources, that they need to be created, and we need to be elevating this as a priority for our community of attorneys. So that is my presentation. Let me see if there are other questions. Here's one. It says voter registration and property records both have options to make your address confidential per statute. And thank you for that comment. And that is absolutely true. Again, I think that it would be worth your time to do a deeper dive to see what level of exposure you have in terms of your information, your personal information being out there in the public ether, and then trying to figure out your level of concern about those things, and then recognizing where you are concerned to try to seek the ability to protect yourself and potentially remove some of those things that you feel like expose you in some way, shape, or form.
And there was one other question, and I wasn't sure if the person felt like you answered or not. Is there anything additional that advice you would give to a new attorney with regards to safety? Seems like you've mostly covered everything. Is there anything else you could think of for an attorney setting up a new office?
Well, I think you're at an advantage. If it is a new office, then you can start with safety at the forefront. Some of what I described to you is we learned about safety after the fact. We've been in this office space that I'm occupying since 2007, and some of the safety protocols that we have put in place happened, 4 years after we've been here, 10 years after we've been here, and I think that's fair that we didn't necessarily know what we didn't know, but I think you should continue to educate yourself. But if you're in the position of being a newer person in the field, and especially again, if you're exposed to potentially these high conflict cases where there is this higher level of threat, start at the safety, start thinking about safety from the very beginning of your setting up your shop. All right, we are at the conclusion of our presentation today. I think most of the questions that were posed to us were answered either in real time, either put in the chat, or the speaker came on after their presentation and responded to you live and gave you the information that you were seeking. I am so happy that you all took the time to spend with us on this Friday afternoon and morning, and we hope that you got something out of it. There will be an opportunity for you to give us feedback. As we were doing this presentation, there were a couple of things that I already thought about in terms of topics for next year, to include danger assessments and lethality assessments, helping attorneys to understand what those are, to be able to help assess risk of harm for clients. Stephen made me think about the existence of DVHRTs and death reviews, and we have a number of those resources within Harris County, Fort Bend County, and I'm not sure if the private bar necessarily understands that those things exist, but they could benefit from those resources, just like any of us who are more heavily involved in this area. So we will potentially think about how to elevate those things in our next seminar. But if you have a topic, if you have a concern that you think that we can cover in the future, we're happy to think about it and put together our best efforts to educate you about X, Y, or Z. But again, on behalf of ABDA, and I can speak for U of H, we again appreciate you all taking the time to attend this particular CLE.